We'll call the meeting to order if we can. Are we streaming yet? We are. Okay, so we'll call the meeting to order. We're still trying to finish the first part of our morning, or the second part of our morning agenda, which is fraud protection, various topics. So with the various topics, we have leading off with Wyoming Secretary of State's office. And I appreciate the diligence, and you guys have been great. Okay.
You know, coming to the rescue.
Is there a possibility while someone's getting the presentation up, someone else can begin the presentation? Mr. Secretary, I was just wondering if we could start the presentation while you're trying to get the written part on the screen.
Yeah.
Appreciate you.
Thank you, Mr. Chairman. Pivoting now to attacking fraud and administrative dissolutions and the topic of fraudulent filings in general. I want to first give you a little history, since I've been secretary, of our background of taking on business fraud and abusive corporate filings. Some of the work we've done in collaboration with this committee and some of our specific requests to this committee. From the day I was sworn into office on taking on business fraud with our existing resources and administratively dissolving business entities who have filed a false or fraudulent document with our office. In early 2023, I tasked our business division through our recently hired director at that time, Mr. Colin Crossman, who's to my right, with utilizing existing Wyoming law to take action against a number of business entities where we have found them to have filed a false or fraudulent document with our office, utilizing a statute which, to my understanding, had never been utilized. And again, the Wyoming Code says that we can dissolve an entity that has filed a fraudulent document with our office. That's different from committing fraud against a person. It's a fraudulent document with our office, which includes the incorporation documents, et cetera, et cetera. To date, we have weaponized this statute to dissolve many fraudulent profit corporations and limited liability companies, processing hundreds of affidavits, a manual process to dissolve fraudulent businesses. That is one of the ways we have addressed and attacked the address fraud issue, which was brought to light in this very room about 2 years ago. We've worked to also convene a working group with Assessor Tara Berg to address that issue more broadly as well. In partnership with federal and state authorities, we have also dissolved entities linked to or found to be owned or controlled by foreign adversaries. And that was because they had filed fraudulent documents with our office when we conducted that audit. That was in 2024 and also recently as well. We have also increased the number of audits of commercial registered agents to ensure compliance with the Wyoming Registered Agents Act. In the first quarter of 2026, we conducted targeted audits of 8 registered agents and are currently in the process of processing and completing action on those audits. Together, we have really changed the tone, and I mean this. I mean, you pull up the press release from 3 predecessors ago when the Panama Papers were released, and 2 predecessors ago when the Pandora Papers were released. It has totally changed because at that time, everybody before me was saying nothing to see here. That being said, we have run up against a wall, which is the current authority in statute. Our authority to dissolve is limited right now pretty much to this one situation. When there is a fraudulent document with our office and when there are entities that are owned or controlled by foreign adversaries. In the 2024 interim session, our administration proposed a number of bills to increase our office's statutory authority to administratively dissolve business entities and take on commercial registered agents. We brought many of these bills to the Wyoming Legislature, including explicit statutory authority to dissolve business entities, which are found to be owned or controlled by foreign government adversaries. That has to be done with the joint law enforcement investigation. Statutory authority to dissolve business entities which provide false or fraudulent information to their registered agents. And some of our proposals, including increased authority and oversight over commercial registered agents, face some pushback. And one of our proposals, which would have required identity verification of third-party filing mills, which include commercial registered agents, be provided to our office, did not make it through the process. So this slide lays out a little bit our authority, 17-16-1420, 17-16-1530, 17-19-1420, 17-19-1530, 17-29-705, 17-30-904. Anything you want to add to that?
No, I mean, Mr. Chairman, if I could just add a little bit, a number of the legislative vehicles that we had, it was Senate File 6 or House Bill 69, excuse me, from the 2025 legislative session, 2024 interim, Senate File 55, I believe, which was the administrative dissolution for entities that provide false information to their commercial registered agents. That was a different twist on those. These are all the statutes that those touch. And so really what they align with is for-profit corporations, nonprofit corporations, both domestic and foreign. Foreign in this context meaning formed under the laws of another state, not Wyoming, so not foreign as in a foreign country, and having a certificate of authority to do business within the state of Wyoming. Nonprofit corporations, domestic and foreign limited liability companies. And I believe some of those statutes also touched administrative dissolution of statutory trusts.
Thank you. Recently, let's go on to the business portal slide. We launched the fraudulent business filing portal on our website, offering a one-stop shop for reporting fraud to our office. Since its launch, we have processed over 90 administrative dissolutions, many citing the website portal as the direct route to submit information. We are continuing to work with federal, state, and local counterparts to target and root out fraud in the state. Secretary of State's office, we now have a one-stop shop complete with a reporting hotline, fillable intake form of the affidavit required, and dedicated email to streamline administrative dissolutions of fraudulent business entities. However, you can go to the next slide. However, we really need a ramp up of authority. We need the help of the legislature to provide the authority with this office to really take on the real problem of fraud. Couple of approaches. One is Representative Lucas's bill, which was a House bill, 26 LSO 462. That's the working draft number. Business entity forced dissolution for fraud. Too often, our office cannot take action because while an entity may have committed fraud on another person, Wyoming law currently requires the fraud or false document to be committed on our office, meaning a fraudulent document filed with our office. This informed our partnership with Representative Ann Lucas in drafting House Bill 125, Business Entity Forced Dissolution for Fraud. Not just when they file false or fraudulent documents with our office, but when they are found to be engaging in fraud, increasing our authority and extending to dissolving entities who have been found criminally or civilly liable for committing fraud on another person or entity. This is an important bill, full support of it. And if we're really going to take on fraud, we need to be serious about stripping the domestic charters of anyone who is found guilty of fraud on another person. Next slide. Then the next approach, which is going even further, and I would advocate for this. This bill basically says that if it's deemed in the public interest, that entities can be dissolved. I mean, this is just draft language, but that's another approach you could go down, which I would support. Now, the Lucas bill is cabined to actual prosecutions, And you could also add there, when it's deemed to be in the public interest. But this would provide really blanket authority and place that determination with the original chartering office, which is the Wyoming Secretary of State's office. And I would encourage you to also pursue this approach. And yes,
Can we just slow down for a little bit?
yeah,
So this isn't something separate. If we could go back one slide.
yeah.
This is, we didn't see 125 in the Senate. That was a failed introduction in the House. But so the next slide is in addition. Is a separate concept, right? Not in a bill right now.
Yeah. So, Mr. Chairman, in attacking fraud, there's a couple different boxes.
Okay.
One of them is in dissolution authority, the blanket authority to dissolve entities, which right now is very, very narrowly tailored. Dissolution is the main action that the chartering agency, meaning the Secretary of State, we would like to have. And when you think about how do you undo a charter, you undo the charter, which is dissolution. So that's really the base of it, is the authority to dissolve entities, which right now under the code is very, very weak. Now, within that box, there's a couple different angles. One is the Lucas Bill, which is allowing dissolutions when there is fraud committed on another person and there's been a prosecution and a conviction. Now, I also think I asked Mr. Rubino to just draft up some conceptual language. This is another sub box within the box of dissolutions. That's what this slide is getting at, that you could just provide the authority with the Secretary of State to dissolve entities if they deem it in the public interest.
So and let me ask about that. So this doesn't require a finding other than the public interest finding. Is that right?
Thank you, Mr. Chairman. Yes. And I think that that's in line with a lot of the frustration here, is that when I hear people in the committee over the last 3 years, is that there isn't this blanket authority. So I'm just providing an option, which I would be fully in support of saying, look, if you want the blanket authority, here's how you would draft it. And I'm fully supportive of it. But I think we've got to get serious on this. We can't have it both ways where people are saying, look, this is an issue and we just want a blanket dissolution authority. And then when we bring it forward, people say, well, this is too much authority. Like, we have to make this choice, and the legislature has to do it. It's not me. And we got to be serious about what are we actually getting at? And so I provided this to say, look, over the last 3 years, there's been a lot of testimony in this committee on, Chuck, hey, take action here. And I say, look, the authority's not there. This is a way you could provide basically unlimited authority, is that the Secretary of State deems it in the public interest to dissolve an entity.
Okay, let's go to the next one.
Yeah, thanks. Let's open up a new box now, which is a different approach to attacking fraud, which is a bill that was brought by Senator Crago over on the Senate side, which has to do with registered agents. Now, these entities contract out with registered agents to receive service, and that's a requirement under the statute. And so what Senator Crago, he brought a bill that would require new information to be collected by the CRA, by the registered agent. And I supported that bill. I was a little troubled because it basically got withdrawn on the House side. I mean, the sponsor said this isn't ready for prime time, which is basically code for withdrawing the bill. And you know how it goes. When you're the lead sponsor, you're the shepherd of the bill. When the person says that, it's basically done. And so this is another approach that I think the committee should take up. As you may remember, we brought through in the 2024 interim the third-party filers bill, which required authentication of third-party filers with our office to ensure those filing documents on behalf of an entity were real people. Unfortunately, that died in the 2025 legislative session. Then in 2026, we testified heavily in favor of Senate File 82, Duties of Registered Agents Amendments, which is on the slide. And both of them, I think, are great bills. One of them is to say, look, These individuals at CRAs that are filing these documents, they need to register with our office because we don't know that they're real people. And that failed over on the House side. And then you have the Crago approach, which is really increasing the information that the CRA has that can then be audited by our office, because the Secretary of State can audit the CRA, but the information that we can audit is quite limited. This also really fits into the requirements of commercial registered agents and requiring commercial registered agents to have certain information on file, specifically the names and address information of an entity's owners, including partners, members, and shareholders, with certain exceptions as specified. To date, Wyoming law requires certain contact information, as I alluded to earlier, which is a somewhat low threshold. But this would be a shift towards requiring more information to be collected that could then be audited, which could then lead to a dissolution. This was characterized as a heightened sort of customer standard for CRAs, and in tandem with some of the recent changes that our office has acted on, could provide more tools to CRAs to actually provide our office with any information if they have reason to believe the entity they represent has given them false information. Remember, we added that as a grounds for dissolution if the CRA was given false information. I'm a huge supporter of this legislation, and I know that this bill had a lot of support out there that kind of crumbled in that House meeting when it was basically withdrawn. But that's sort of in the CRA box, which is the bill that failed in the 2025 legislative session, and around having third-party filers register with our office. And then this bill, which failed in the 26th session, duties of registered agents amendments. And then let's go ahead and open up the third box, which is deed fraud. Mr. Chairman, turning to another form of fraud affecting Wyoming residents, deed fraud. Deed fraud occurs when a bad actor records a forged deed, mortgage, or other instrument in the chain of title with the county clerk's office, purporting to transfer or encumber property without the true owner's knowledge. This is a growing problem nationally. The FBI reports of real estate fraud losses in the hundreds of millions annually, and Wyoming is not immune. Typical victims are elderly landowners, those who own property free and clear, or owners of rural land they don't visit frequently. Under current law, there is no mechanism for a property owner to proactively protect their property from fraudulent filings. Some options exist in the market: software services that monitor deed filings and alert property owners when something is recorded against their property. But these are fundamentally reactive, notifying the owner only after the damage is done. And they require integration with county systems that may not be feasible across all 23 counties. One concept we're examining is a voluntary protective instrument that owners could record, which would render any subsequent voluntary transfer void, unless the owner first appears in person before the county clerk to remove it. This creates a proactive legal barrier rather than a reactive notification. A forged deed would simply have no legal effect, without requiring the victim to pursue expensive title litigation. Importantly, this would not prevent legitimate involuntary filings, mechanics liens, judgment liens, tax sales, foreclosures, and similar instruments would still be recorded and enforceable as they are today. Because the protective instrument is simply recorded in the chain of title, it works within the systems clerks already use. No new software integration required and no liability for the clerks. For entity-owned property, we could tie such protection to good standing with our office, creating additional incentive for annual report compliance. We wanted to brief the committee on this. I think Mr. Crossman and Mr. Rubino have taken a lot of interest in this issue, have convened a couple working groups with citizens in Wyoming that are very concerned about this. So I'll let them add on a little bit. Go ahead, Mr. Crossman. With the chairman's.
Thank you, Mr. Chairman. I believe Representative Guggemos is going to present significantly on this. He was heading up one of the working groups that we had with citizens. So I believe he's going to be bringing much more detail. So I would, rather than preempt him, I'll let him get into it. And if you want to call me back up later, I can do that.
That sounds great. Let's wait and hear from the representative.
That's, yeah. I want to have one more fourth box to open here as we conclude. One other issue is the software filings in our office, the software system in which you file your entities. And that was rejected by the legislature, our request for a new system in 2024. One of the things we wanted to do with that system was have this partnership with a software vendor that would allow us to attack the address fraud. And Mr. Rubino, do you want to maybe elaborate on that a little bit, how that would have worked?
Go ahead, Mr. Rubino. Or Mr. Crossman, or
All right.
I am. Go ahead,
Thank you,
Mr.
Mr. Chairman.
Crossman.
So right now, our system is when the state of Wyoming developed it, it was state of the art. This was going on 20 years ago. This system does not have the ability to search addresses for flagged addresses beyond a couple of very simple addresses, such as if you put the capital down. The newer softwares now have that ability to not just track the addresses entered, but match it with do pattern matching and behavioral matching as the entities are being filed to make sure that at least some checks are being done, that the address entered is a real address, that it's at least somehow linked to you, potentially. A lot of this is done with an integration through the big credit bureaus like TransUnion. So this is not something that we could essentially do in-house easily because it uses a lot of external data coming in. But these things would minimize or significantly reduce the amount of fraud in credit card processing, because we do see that. And those are the ones where people are filing entities at locations that they have no connection to. As well as fraud where they're paying for something and then putting the addresses down that they don't have a connection to, but using a registered agent. So this gets at two of the largest buckets of fraud that are happening right now, that are the lowest hanging fruit, essentially, so that we can directly eliminate those or minimize them to the extent possible. Other states have started to implement these. There's Tecuity, which is the vendor that we use for our current software, does have that capability now. They're the ones that do TransUnion. I think some of the others use other credit bureaus, but basically it's the same kind of thing where you take a credit card into a store and they say, hey, this is out of your pattern. What are you doing? We're going to deny that. We kind of, that technology gets applied to the formation of a corporation with respect to the addresses being used and the payment and where you're coming from, what your IP address is and things like that.
Very good. You'll get us more detail. What is the estimated cost of all that?
You want to go?
Mr. Rubino?
I can go ahead and take that. I would refer back to our submitted budget request, which would have been, which would have included that something like that more readily, right? The upgrade, rather than attaching it to a legacy system, which you're sort of putting on new parts onto an old system, the upgrade would have included a lot more of those add-ons that would have done that. Obviously, that was submitted to the legislature in the 2024 budget session. That was ultimately not taken up by the legislature. If that's something that the legislature would like to go down, and I know Mr. Pope had submitted, he had sort of if you look at his committee handouts, he had looked at another state, Nevada, they spent approximately, I think, what was it, $10 million to upgrade their business filing system. And it incorporated some of those pattern recognition credit bureau changes. Our proposed upgrade, the entire upgrade, was, I believe, it was a lot less. But that's one of the things that, is maybe being discussed today. And if those are sort of some a la carte options where the committee would like to look at different tools with our existing systems, such as credit bureau integration, that could be something that we could certainly work with our existing system to determine what a cabin solution for that would be.
Thank you, Mr. Rubino. And then just in terms of strategy, if the committee wanted to support this upgrade and capabilities, which sounds important to me, we could do it as simply as supporting your budget requests that you make, but we could also do a bill. So appreciate your thoughts on what that might look like.
Thank you, Mr. Chairman. Yeah, you could do a bill. You could wait for the next budget request, which obviously either of those would be with the next Secretary of State. So I do want to make clear, though, because Senator Boner's asked this question in the past, and I really appreciate it. Is this the answer? And my answer to that is it's part of the answer. This gets at address fraud, some pieces around having a login, because one part of this, and look, I get tired of all these logins, but they do increase security. And now on our website, you're going to have a login if we do this upgrade. And so that's going to increase some aspect of security, but it's not a panacea. The issue of people hiding behind CRAs, the structure of our statute is deeper than that. And then the authority to dissolve. But it'll provide some more upfront protections, which I think there was some, I heard some of that, especially in 2024 around the address issue. We're largely reactive around the dissolution authority. Well, this is upfront protection around address fraud, and by having that login, some of the other sources of fraud that we're seeing. But it's not a panacea on dissolution authority once they have the entity and fraud committed against another person. So I appreciate Senator Boner's question during the session. It is not an answer to the fraud in its entirety. It's one piece of it. And that's what I want to leave you with is the importance of this. I really think the time to address this is way past. We need to get some of these approaches done. And whether we're going towards a working group or bill drafts, or I don't know where this is going today with the committee, but I encourage all the above. And I think it needs to be a full force approach, not just one thing. There's multiple layers of addressing the fraud and strengthening our statutes.
Very much appreciate your work today, Mr. Secretary and staff. It'll be up to the committee. We could have bills drafted, and some of them have already been drafted, like Representative Lucas's bill, for consideration at our next meeting. We could also have a bill drafted supporting the improvements in the office with respect to software. So the sky's kind of the limit. Are there questions for these three gentlemen right now? Let's start with Boner and then go to Yin.
Thank you, Mr. Chairman. I'm wondering, if we're talking about the software upgrades, not to be a dead horse, but if we were to accomplish those upgrades, would it eliminate the need for any of those bills? Maybe one or two, or would it solve part of the problem you said, but I was wondering if it would eliminate the need for maybe one or two of those bills that we've been discussing this afternoon.
Mr. Secretary.
Thank you, Mr. Chairman. I don't think so, really. I mean, the dissolution authority is really the reactive approach, and you have to have that in certain situations. The system gets more of an upfront layer of protection for the people of the state of Wyoming. Maybe third-party filers is a little bit less necessary, the first iteration around registered agents, but I still think I would be for it, because you do have that login. So having them register with our office, there's an argument to make that maybe the login in some way mitigates some of that issue. I would still be for the third-party filers bill that came out of the working group in 2025. And then the Crago bill, which is a whole different area and relates to our auditing of the registered agents as well. When we audit a registered agent and they have basically no information because the statute doesn't require them to basically have almost anything, then how do we get grounds for dissolution when we have a problem? So That's what I think the Crago bill gets at, which is a different layer of the problem. And it's very different from CTA. People have tried to compare this. Mr. Pope, I've worked with him on a lot of issues, appreciate him. But I think comparing the Crago bill to CTA, I mean, we've been down this road, but I know you guys have a lot of things in front of you. So just to reopen this, you know, I know Mr. Pope is probably going to testify. I think comparing the Senate bill, or the bill that passed the Senate that was then basically withdrawn, to the CTA is false. Having the registered agent collect this information is very different from the federal government collecting this information. And so it's just a very different situation, my opinion.
Everybody, I suspect we're kind of a friendly audience. We're in the fourth quarter of the game here, and really we're not going to solve all this. We're going to decide whether we want to look into it more and have a draft in front of us. So we don't have to really argue all the merits. And it's Memorial Day weekend, and Representative Yin.
Mr. Chairman, thank you, Mr. Secretary. So I like some of these approaches. Some of them, I think we should put some thought into them. I'm curious, and maybe Mr. Rubino, you can help me out with this. What happens if, with fraud, usually there's someone that has been defrauded and they are seeking recompense. If we dissolve the entity before that has happened, how are there still mechanisms for them to be recompensed?
Mr. Rubino?
Thank you, Mr. Chairman. Representative Yin. I'm happy to take a stab at that. And I think I understand your question to mean that what occurs if there is civil or criminal fraud committed by an entity, and simultaneously with a civil or criminal, or let's say we have a judgment, because that's, I think, what this House bill, Representative Lucas's House bill, really addressed, was that there had to be either a civil or criminal judgment that was entered by a court. But let's say there was one entered and it was on appeal or something like that, and something was pending. I think that you're looking at a number of different things. For one, entities are found, just getting back to, corporate law, why we have corporate existence is because they're supposed to be separate and distinct from their owners themselves. So you're not found individually liable. When you have a fraudulent entity, that's actually one of the number one factors. It's actually a predominating factor under Wyoming law and law around the country for the doctrine of piercing the corporate veil, where you can find an individual owner individually liable for the actions of an entity that they are purporting to hide behind. And I would guess that if you have a judgment, whether criminal or civil, that there has been fraud committed, a resulting action based on that from the Secretary of State's office administratively dissolving that entity, it would be yet another factor that a court would consider for finding the individual behind that entity individually liable for that fraud. I don't know if that answers your question or if that gets at what your question was.
I think Mr. Crossman wants to weigh in.
Thank you, Mr. Chairman. As a sort of an additional matter, piercing the corporate veil being the most important one, but any dissolution in Wyoming under our statute is not a final end of the corporation. The corporation continues to exist for the purposes of winding up. An administrative dissolution in our case is is one that's initiated by our office. But to look at a situation where a corporation voluntarily dissolves, a corporation can't get out of liability by voluntarily dissolving. The corporation still exists while it has those debts out there. So for those purposes, the corporation, it is no longer allowed to carry on normal business operations, but it exists until it is fully wound up. All of its assets are distributed and there's nothing left. So for that, the dissolution isn't actually like a death sentence.
Fair enough. Anybody else? Anybody else over here? With regard to the bill about or the proposal to have the Secretary of State have stronger ability to dissolve a corporation, I think it might have been mentioned that it's kind of unlimited power to dissolve a corporation. Is there any due process remedies that you envision? Can an entity go to court and push back on your finding? What are we thinking there?
Well, Mr. Chairman, I think at any point an entity could file something in court saying that it wasn't done according to the public interest. But I mean, the limiting factors would be set by the legislature. And I think that it should just be a public interest determination. This is a elected office by the citizens of the people of Wyoming. And I think ultimately that's going to be the determining factor is at the ballot box. And obviously, that determination of what's in the public interest. That would be my recommendation, but you could set out some more limiting factors. I think there's always the ability to challenge in court, though.
So, Mr. Secretary, let me play a devil's advocate. That we have someone that is the Secretary of State and maybe hostile towards particular political persuasions or what have you, and they find that some activity that is corporately enveloped is not in the public interest. And it might be for, say there's a political motivation, say there's a personal motivation. It seems like there's a potential for abuse there. And I'm wondering how we could tighten that up. I'm not opposed to the giving more power. I'm not. I really am not. I'm with you on that. But I'm wondering how we can put sideboards on it so that it can't be used in a politically abusive sense. Maybe go after corporate entities that are nonprofits that have a political persuasion, on and on.
Well, Mr. Chairman, I think the Lucas bill, it's majorly limiting because you have to have a adjudication. But that's one. But honestly, when I see the Lucas bill, I like the Lucas bill, but it's majorly limiting. You know, you have to have that judgment. I guess you could put good faith, public interest. But, you know, at some point, I think at some point we have to decide is the chartering authority going to be able to make this decision to dissolve or not? And if they're not, if you're going to put all these legal sort of stipulations on it, then it's going to be very difficult to do unless one of those is met. And this is what I'm trying to get at, the overall theme of these comments. I mean, I've been in this for 3 years and a half, and I'm in good faith. I love policy. I love trying to get at an issue. But this issue, I think you got to pick a path here. Are we going to provide that authority or not? And then if it's not, then that has to be explained. But right now it's not there. And that's just reality in most instances.
Fair enough. We will discuss it. Are there any other questions on the thing so far? Would it be appropriate to go to the representative and take that up, or Mr. Rubino? Certainly, I'm not trying to cut you off.
Well, Mr. Chairman, I'll be very brief. I just wanted to add on a little bit of that. It informed a lot of our work in 2024 and 2025, and good work with this committee was out of specific instances that either were not quite brought to our attention, we were made aware of them, but when we reviewed them with ourselves and putting our heads together, we looked at the statute and we said, oh, I don't know. I don't think this is there for that. This entity provided false information to their registered agent, for example, but they did not submit anything false to us. We don't have any authority to do that. So the legislature passed this bill. Same with the foreign adversaries, and we're very thankful to that. We used some creative thinking to administratively dissolve those entities that we knew from our joint investigation with the FBI were tied to North Korea, but it wasn't under the authority that we have now, which came out of the work that we had with the legislature. And so a lot of it, what the secretary I think is getting at is that, you know, in the kind of whack-a-mole things, these instances come up, we look at it and we say, oh gosh, we don't have authority for this instance to dissolve this entity. But if we pass this bill, we could do it. And we've done that. And we've had a lot of good work with you over the interim doing that. I think that's sort of where we're getting this tension now, is how to get upfront things and more of that so that there's not a reactive, not just reactive for administrative dissolutions, but reactive to pass legislation so that I think we administratively dissolved, Mr. Crossman administratively dissolved one entity under Senate File 55 12 hours after that was signed by the governor, because we were, we were waiting for that to be done, and we did it that day, actually. So
Thank you for that perspective. Should we take up Representative Gugelmoss, and is he by himself, or is he partnering with your office, or how's that work? Representative Gugelmoss, welcome.
Thank you, Mr. Chairman, committee.
Welcome.
I am Joel Guggenmoss, House District 55 representative. In discussing the deed fraud protection, I am bringing for your consideration a bill draft called the Wyoming Rock Notice Act. Now, this Wyoming Rock Notice Act would create a new recordable instrument, the Registered Owner Contact and Key, or ROC notice, that property owners can file in the chain of title. Once recorded, a ROC notice renders any subsequent voluntary transfer of the property void as a matter of law, unless the notice is first removed through a verified in-person process. The notice does not interfere with involuntary transfers or involuntary liens. And there's also a 7-year expiration unless it is renewed. Now, other states have tried to address this problem, but they usually don't hit the mark. They're reactionary or don't go far enough or fast enough. The ROC Notice Act would create Title 34, Chapter 30 in the Wyoming statute. It establishes a new recordable instrument that property owners can voluntarily file in the chain of title. The act is organized into 7 articles: general provisions, filing by natural persons, filing by entities, legal effect, duration and removal, title insurance obligations, and administration. Now, the mechanism of this act and how it would work is an owner records a ROC notice with the county clerk. The notice is indexed in the chain of title. From that point forward, any voluntary transfer, deed, mortgage, easement, quitclaim, deed of trust, lease, option, or contract for deed recorded after the ROC notice is void as a matter of law. Not voidable, void. It conveys no interest and has no legal effect, regardless of whether the parties knew about the ROC notice. Now, to remove the ROC notice before a legitimate transaction, the owner must physically appear before the county clerk and present government-issued photographic identification and execute a removal notice acknowledged before the clerk. This personal appearance requirement is the security mechanism. A forged document, a fake ID presented to a remote notary or fabricated corporate authority cannot satisfy this. Now, filing by natural persons. Any natural person who owns real property in Wyoming may file a ROC notice. Where property is held by multiple owners, joint tenants, tenants in common, or tenants by the entireties, all owners must jointly execute and file. Now, filing by entities. A significant amount of Wyoming real property is held by LLCs, corporations, and trusts. The Act permits entity filing subject to eligibility requirements. The entity must be a domestic Wyoming entity or a foreign entity qualified to transact business in Wyoming. Must be in good standing, and the notice must be executed by authorized representatives sufficient to bind the entity. Now, there are a few additional compliance obligations for entity filers, such as duplicate filing with the Secretary of State annual report disclosure, and good standing requirements. Void, not voidable. Now, this is very important. A voidable instrument gives the property owner a cause of action to set aside the fraudulent transfer in court. This is already a matter of law. The ROC notice goes further. The fraudulent instrument never had legal effect. No quiet claim action or quiet title action is needed. The void instrument can be cleared from the chain of title by recording a simple affidavit citing the statute. The difference is between years of litigation and lots of money or a single filing. As stated before, this does not interfere with liens and stuff that are put on the titles. And there is a 7-year term. After 7 years, the ROC notice will expire if not renewed, preventing dormant title problems and ensuring that contact information stays current. Renewal requires updated contact information and re-execution by all current owners. This periodic renewal cycle also confirms that ownership has not changed since the original filing. Now, removal of this. The removal requires personal appearance before the county clerk. The act prohibits removal by power of attorney, by agent, or by any means other than physical presence, except in 4 specifically enumerated circumstances: death, incapacity, entity dissolution, and bankruptcy. And those are stipulated in the actual bill draft. It goes into detail on how that would happen. Title insurance interaction. The act requires title insurers to search for ROC notices before issuing a policy. If a notice is found, the insurer must disclose it to the proposed insured and may decline to issue, require removal as a condition of closing, or issue with an exception. If a title insurer fails to conduct a reasonable search and fails to discover a ROC notice that would have been found by such a search, the insurer cannot deny a claim based on the notice or the invalidity of a void instrument. The insured recovers as if the ROC notice had not existed. This creates a direct incentive for thorough searches while preventing insurers from using the existence of the ROC notice as a technicality to deny claims. The administration and fiscal impacts. The county clerks. This act imposes minimal new duties on county clerks. Clerks continue to perform their existing ministerial recording function. They are not required to determine whether a ROC notice affects any instrument presented for recording, are not required to refuse recording, and are not required to provide expiration notices. The act provides immunity for clerks and their staff for actions taken in good faith. For the Secretary of State, the Secretary of State's office would maintain a registry of ROC notices filed by entities, indexed by entity name, filing number, county, and legal description. This registry enables title companies to cross-check entity standing and monitor compliance with annual report disclosure requirements. The Secretary of State would also process annual report disclosures from entity filers, send certified mail notices to entity filers that enter administrative dissolution during their 90-day cure period, and notify county clerks upon expiration of that cure period. Yes.
You getting close to finishing up?
Yep.
Okay,
Yes,
good.
sir. The Secretary of State is authorized to establish fees for filing under this act, not to exceed comparable fees under Title 17, and is granted rulemaking authority to implement the act. Let's see. So as far as the stakeholders, the property owners gain a voluntary low-cost tool to prevent fraudulent conveyances. Title insurance companies. The ROC notice is a clear searchable instrument in the grantor-grantee index. It reduces fraud claims, fraud claim volume by preventing fraudulent transfers from having legal effect, and insurers gain an unambiguous mechanism to manage risk. Real estate professionals, closing agents, attorneys gain a straightforward tool to advise clients on fraud prevention, and lenders and others, secured creditors, benefit from knowing that properties in their portfolio are protected from the fraudulent transfers that could impair their security interests. And with
Okay.
that, I'll stand for questions.
Thanks. Any questions for the representative? Any questions? Representative Locke?
Thank you, Mr. Chairman, and Representative Gugelmas, thank you for presenting that. So just real quickly, so it doesn't affect the normal flow of liens, anything like that. It just blocks title changes is roughly what it does to ensure they do not happen. Is that accurate?
That is correct.
Representative Google.
Oh, Mr. Chairman, thank you. Yes, that is correct.
Anybody else? Anybody else? Senator Land?
Thank you, Representative. Appreciate your comments this afternoon. So is this a compact type bill? Has it been stood up in other states? Is this, I'm just curious what the origins are and where it came from.
Representative Google.
Thank you, Mr. Chairman. No, this has not been done in any other state. This would be a first.
Okay.
It was an idea that I just brought forward, and I've been working with people who know more about this area than I do, and this is kind of what we came up with.
Congrats. Thank you. Appreciate it.
Representative Yen?
Mr. Chairman, thank you. Representative Gugelmas, so, I mean, this is a 37-page document, single space. It's probably going to be a 100-page bill in our bill formatting, which is a lot. I mean, which, not necessarily bad because we are a committee and so we can work a 100-page bill. I'm curious, one, I think you could do some of this without the clerk. I think you could probably structure some of this in a way with a notary and do something outside of the realm of us passing a law for it. But I'm curious on if you talked with any title companies or who did you speak to that would also be able to come speak to us and say, this makes sense, we would do this so someone wouldn't take our customer's land or something like that.
Representative Google.
Thank you, Mr. Chairman. Representative Yen. I was originally going to run this as a personal bill, and I would have reached out to all those individuals, but I decided this is such a complex issue that it merited and warranted a committee, a joint interim committee working on this, because I knew it was going to be involved and it was probably more than I could handle alone. So I did not reach out to them.
Anybody else? Anybody else? Representative Luca?
Thank you, Mr. Chairman. Representative Gugelmas, I'm pretty impressed. This is quite a lot. And as a former banker, I see the need that we need some kind of protection like this, because in reality, titles are falsified and stolen, if you will, from homeowners pretty frequently. So incapacity, I'm just, because honestly, I haven't read all 37 pages of this at this moment. Incapacity would be allowed, then a power of attorney or a durable power of attorney would be permitted. That was the question, sorry.
Thank you, Mr. Chairman. Yes, I believe a court-appointed guardian or conservator may remove the notice, as may an agent under a durable power of attorney with express real property authority, subject to safeguards, including a physician's statement and best interest affidavit.
Anybody else? Anybody else? Representative Heft?
Thank you, Mr. Chairman. Representative Gugelmas, this may seem like a very small thing compared to this bill, but at the end of the 7-year filing period, would there be notice to the owner that it had expired?
Representative?
Thank you, Mr. Chairman. That's a good question. I think maybe that should be stipulated in the bill, that notice would need to be sent. I think that would be reasonable.
Anybody else? Representative?
Mr. Chairman, thank you. Representative Gugelmas, what happens if the owner dies. Is that in here?
I think that was one of the 4 terminating
Okay.
things you mentioned.
Thank you.
Um,
Does the clerk verify that?
I guess she goes and looks at the body.
Okay.
Anybody else? Sorry, you guys, it's getting late. Anybody else? Representative Google Moss, just at a very, very high level, this is an instrument that is filed and attached to a property deed that notifies anyone that's going to make changes to the deed or change of ownership, that the only way a change of ownership can occur is if the original filer of this rock notice appears in person with the proper identification, and that's verified. At a very high level, that's all this does, right?
Yes, that is correct, except
Okay.
in those enumerated conditions
Yeah.
where the original was not able to show up.
All right. I wonder if it needs to be this long to accomplish that. I don't know. But I just want to make sure I understand the concept. Any other questions? I'm trying to decide how to proceed here. We've got Mr. Pope online. Certainly the county clerks have to weigh in on every one of these, and we could do boom, 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 boom. But I was thinking we'd let Mr. Pope present his concept, and then have the county clerks and everybody weigh in and begin the public comment on everything that's been said so far this afternoon. Is that acceptable or not? Ms. Talbot? Oh, yeah, we do have Representative Larson too. Is he online? Is that where that is? Is it okay if we take Representative Larson first and then we'll go to Mr. Pope? And you guys, I'm begging everybody that's still to present to be short because we're still on our morning agenda. And 4 people here have to drive hundreds of miles and it's Memorial Day weekend. So please help us out. Representative Larson.
Thank you, Mr. Chairman, members of the committee. Can you hear me okay?
Yes, we can, I believe.
Thank you, Mr. Chairman. I come before you today to talk about an issue that arose a couple of years ago when a filing was presented to the clerk of Fremont County regarding an action against one of our circuit court judges on, as he states, a citizen status entered a plea against his will. And the judge, the individual that brought this filing against the circuit court judge is making a claim of $30.6 million to be recorded against the judge in the clerk's office. What we find is that in some of these cases where there are arguably fraud or frivolous filings that are recorded, and these recordings, according to our clerk, stay on the records for there's no mechanism to remove them or to prevent them, can cause an undue burden on the individual that's being the claims being made against. And that's oftentimes a public official, a clerk of court, a judge. I've got another one that I submitted to you in your documents that is our Justice of the Supreme Court and our Supreme Court Administrator and the Fremont County Clerk of Courts, and it was preparing to address and work out a means that would give the authority to call these filings frivolous and not need to record them, and had House Bill 104 this session. As we was preparing to look at that bill, Mr. Crossman, the Secretary of State's office, approached me and asked how that would apply also to those similar filings in the Secretary of State's office. I had not contemplated that, and I made a request to Mr. Crossman if he could possibly research and look at what other states have done and see if that's something that he's seeing across the nation, both in county and the Secretary of State's offices. He identified that there's 20 other states that have already addressed the ability for clerks and secretaries of states to have administrative authority to determine if these types of actions are fraudulent. You know, to illustrate how far out some of these are, there was an additional handout that was provided to you that talks about Fremont County Clerk of Court and the Wyoming Supreme Court Justice and Clerk Administrator, and the just the first sentence. God loves launch nuclear missiles at all planets. Courts charge court fees. When 100% nobody wins in court, God loves collapsed planet atmosphere, zero gravity. We go in a little bit further, and it talks about the guy alleges defendants of the Wyoming Supreme Court, UR Energy, Terra Power, Amanda Sanchez, Shonda Goetz, Chief Justice Lynn Baumgartner conspired to conceal putting human body parts cannibalism at these various places around the state. It's fascinating read. If you haven't read it, you ought to take a look at it. But then he makes a claim. This guy makes a claim that his civil rights were violated and demands $10 million. We envisioned with Mr. Crossman and with Mrs. Freese, we talked about this as becoming more common than perhaps it was historically. Our hope today is to help educate you a little more, and we would like to look at what other states have done and come back with you at your next meeting with a draft bill that could appropriately take care of this issue. And so, Mr. Chairman, if you wouldn't mind, I'd like to call on Mr. Grossman. He done a great job of researching this. This was in your handout materials as well on what other states have done in the matter. And then maybe we could be blessed with Mrs. Freese's thoughts on this matter as well. Thank you.
Thank you, Representative. Any questions for the representative at this point? And so, Representative, if I understand it right, you're saying we wouldn't necessarily start with House Bill 104. You're going to come back with something a little bit different. Is that appropriate?
Mr. Chairman, the mechanism I used in House Bill 104 and the breadth of 104 was just insufficient, and there's a better means. It would, and I think we found that out as we've seen what other states would do. So we would just can 104 and start with a different draft that would address both on the county and state level.
Gotcha. Okay, we understand. We'll go to Mr. Crossman.
Thank you, Mr. Chairman. And in part 7 of the handout that Representative Larson provided you, there is a beginnings of a proposed language. This hopefully LSO would be able to work with that to start drafting things. But one of the reasons that I had identified that House 104 was, I think, maybe a little bit insufficient is because it would require, for every single filing that was deemed frivolous, it would require a court action affirmatively, which, you know, that's a great protection, but that's also relatively expensive, time consuming, and you know, these frivolous filings are frivolous, so they can be generated with very little cost, and now you're having to expend a lot of staff time and effort to go to court every single time you get one. So as part of the research that I did, and this goes also to, I think, an additional document that Representative Larson, I think, provided, which was the NASS, which goes to the UCC component of this. But there is a couple of Supreme Court cases that have demonstrated that when a document is manifestly frivolous on its face, that as long as a route to the court exists, then constitutional protections are satisfied. So this would allow the Secretary of State's office, the clerk's office, any other traditional filing office in the state that receives a frivolous document. Now the draft language may have to be adapted for other offices, but to just say no, you know, here's how you appeal this, but we're not taking that, and that just allows us to cut the chaff out. And other states have done this. About 20 other states have done this in the UCC, which, as you know, the Uniform Commercial Code is now not uniform because those states allow their filing offices to say, yeah, that isn't real. So Wyoming is one of the states that currently does not have that mechanism. And yeah, we've seen some interesting things.
Fair enough. Questions for Mr. Crossman? Thank you. Ms. Rubino, you have anything? You're just along for the ride. Thank you very much. Ms. Freese, did you want to address this one? And you're going to get your chance to address everything else that we've covered before, but you were called out by the good Representative Larson.
Mr. Chairman, members of the committee, don't want to let the representative down. I think the only thing that I could add to that is, and that was a conversation I had with the last bill, that there's a great difference between UCC and land recordings, and liens are filed sometimes in either location. So I think as clerks, we're willing to look into how to help with any of these situations. I have been looking at what was sent on this. It's much better than it was when we first drafted it for the legislature, so I'm glad we took some time to do that. So again, we're looking at it with them and just wanting to make sure that when you're filing it, recording is permanent. And so it's not like you can go and take it back off, just so you know, it's there. So whatever, so if somebody files a deed and it's wrong, the assessor lets them know it's wrong, and then they have to file again to say, oh, I messed that up and I'm going to not re-record it, but to record it again as a corrected. And so just to kind of give you that kind of a mindset of what you're looking at, either direction that you go on that, so.
Thank you very much. Any questions for Ms. Freese? Thank you. Thank you, Clerk Freese. Anything else from the committee? Anything else from you, Representative Larson?
No, Mr. Chairman, just trying to catch you up on time a little.
We do appreciate that. So, okay, we'll mark that, and we're going to come back to all these fraud things together and go through them as the committee and get some direction. But the next one, I think, is it Mr. Pope? Is he the next one? Mr. Pope?
Thank you, Mr. Chairman. I appreciate the opportunity, and I'm hoping everyone can hear me okay. My
Yes,
name is...
You're loud and clear.
Thank you. My name is David Pope. I'm a certified public accountant, a chartered global management accountant, and I'm licensed in Wyoming and Colorado. I am a commissioner on the Wyoming Stable Token Commission, and I serve as one of the governor's liaisons to the Wyoming Select Committee on Blockchain, Financial Technology, and Digital Innovation. I'm the president, CEO, and founder of DAP CPA Certified Public Accountants, and that firm serves 4,000 roughly clients, most of which reside within the state of Wyoming, concentration in Laramie County and Fremont County, and I really wish I could have been there today because I love my trips up there. So my apologies for appearing remotely. We do have clients in every single county and district within Wyoming, and I think that what the committee is going to believe is that I'm going to just come on and oppose everything, and I want to share right now that if your constituents are having a problem with fraud, my clients are having a problem with fraud, and I don't in any world want that to happen. So what I truly believe is that if we are planning policy here, that the policy should be effective, and it should be then implemented, and it should actually do what we want it to do. So I provided a lot of materials. I'm not going to take up a tremendous amount of time because I'd rather answer questions on the materials than rehash it. But I'd like to go over just a couple of things that came up in listening to previous testimony. I think one of the things that I would actively oppose is any kind of language that said something like contrary to public policy or public interest. I lived through, as all of us did, the Operation Choke Point on the federal level, and that's something where a political decisions were made about debanking perfectly legal industries, and those included industries that we know and love. Mineral interests or parts of the mineral industry, extraction industry, firearms, all of that. And giving that broad of power to anyone, I think is not something I'd like to see. I think many things that the good secretary suggested, I think that we can work with, and we can find the right language to make it work to avoid and help eliminate fraud. Because I think that if you're looking at if there is a loophole, someone will find it and someone will exploit it, and so we need to tighten the loopholes. I think a big part of that is the software upgrade that the Secretary's office, Mr. Crossman, I think, talked about it. The Secretary might have talked about it. Nevada did it with their Orion system. Cost them, I think, a total of about $13 million. Upgrading our current system would make it comparable to the Orion system. I just had no idea when I wrote my materials that that was a possibility. But if it's comparable to the Orion system, it would allow us to do pattern recognition, probabilities, all of that, which is integral to fraud protection. And it would allow us to become, the Secretary of State's office, to become an effective, or have an effective, enforcement division. I also believe we need additional enforcement personnel. It's not fun to look at adding additional permanent employees to the state. None of us likes increasing the budget for that. But when you look at it at that compared to the option of what the prior legislation from this session would have done, the cost offset is tremendous. You could have seen a $20 million loss to the general fund, if not more, $20 to $30 million loss to the general fund. And if it costs $3 million to upgrade our systems and another $400,000 a year for three dedicated enforcement personnel, I think that's a really good trade-off. I do believe
Mr. Pope?
Yes.
Hey, it's late on a Friday afternoon,
I get it.
and everybody here's got to drive hundreds of miles, pretty
Okay.
much. So you can say the same thing with fewer words. I know you can. You're a clever man. So I'm putting the pressure on you.
We'll sit down sometime and maybe I can be coached on it. So I think this entire process needs a working group. That's at the bottom line. I think there needs to be a legislative working group, a couple of industry folks, and a couple of and at least one person from the Secretary of State's office, because this is a complex issue. I've got a whole list of things that I believe are that will be very effective at it. So I will go ahead and finish with that, and say that I am all aboard the issue of finding fraud, and we're rooting it out. But I also need to say that I think it needs to be looked at from a lot of angles. I will leave that as my last comment and stand for questions. And thank you again, Mr. Chairman, and the rest of the committee for listening to me.
Thank you very much, Mr. Pope, and thanks for your good sportsmanship. Your point is loud and clear. We do have it. Any questions from the committee for Mr. Pope? And we appreciate it. Appreciate the other information as well. Thank you. Any other direct testimony on the fraud issue? Yeah, Ms. Lee.
Thank you, Mr. Chairman, and I will be very brief. Good afternoon, and thank you to the committee. My name is Kristen Lee, and I represent the Wyoming Trust Association. We are absolutely opposed to fraud. It goes without saying. If the committee chooses to move forward with what Mr. Secretary called the Crago bill, which was Senate File 82, we really think it needs more work for a lot of reasons that have been stated, and we'd like to go with a small working group that definitely includes the Secretary of State's office. The Trust Association would make some exemptions there, and we would work on it. We actually have it drafted if the committee decides to go forward with that. Having said all that, if we really, really want to get serious about fraud, please, we support an upgrade to the Secretary of State's software program. There's lots of software out there, I'm given to understand, that can really address this and be the enforcement mechanism. The registered agent probably does not do what you hope, doesn't solve what you're solving for several reasons, but that would be fleshed out in the small working group. So thank you for your time.
Any questions for Ms. Lee? Ms. Lee, what I heard from you is you don't like Crago's bill, but
We'd like to work on it.
You have a proposed alternative. Did I hear that?
We do.
And you definitely support the software upgrade.
Correct.
Okay, loud and clear. Thank you very much. Ms. Smith, we're not at your bill yet. You're just jumping in here. Okay. Ms. Smith.
Thank you, Mr. Chairman, members of the committee. My name is Marion Smith. I am the Strategic Government Affairs Policy Director for the National Insurance Crime Bureau. With a 115-year history, our organization is the nation's leading nonprofit organization exclusively dedicated to combating insurance fraud and related crimes through intelligence-driven operations. We're supported by approximately 1,200 property and casualty insurance companies, including those in Wyoming. And through investigative support to support not only our members and law enforcement intelligence reports, information sharing, we're here to help stem the nearly $300 billion efforts within fraud. But so that's my intro to part two of who I am and who NICB is. But regarding registered agents, and specifically to Senator Crago's bill, I think it's very timely. I received an email just yesterday from one of our special agents in Arizona, knowing that LLCs can be formed all over the country using registered agents as a shield to protect their identity. So I received this yesterday again from our special agent in Arizona. I'm reaching out in regards to a business, and let me proceed that this is an active investigation, so I will not be stating the names. I'm reaching out in regards to a business that we have in Arizona that is registering its LLC in Wyoming. The business is inclusive of multiple LLCs, of which 3 of them are registered and incorporated in Wyoming using registered agents. These business entities are currently being investigated for allegations regarding to insurance fraud and patient harm. However, we are unable to verify the owners of the Wyoming LLCs. It is greatly hindering our ability to pursue these entities. If you have any additional information that you can provide to assist us in helping find the owners of the Wyoming LLC, I would greatly appreciate it. With our registered agent statutes, it's nearly impossible without a subpoena to find out who these individuals are. And this is not a judgment. This is just an investigation. We cannot even investigate criminal activities that are being conducted by actual people, actual addresses. These are not fake people. These are real people. And they're using registered agents in Wyoming as a shield to conduct business. And Wyoming should be very proud of our LLC laws. And these kind of communications that I hear repeatedly from our special agents. We can go into a lot of other issues, but this was so timely. I think it's very imperative that you look at our registered agent laws and correct the fraud there. Software is software, but they're doing all the right things. An audit of software, they're going by the laws, with the exception of what they're doing to their patients and to the insurance community, which hurts all of us. So I'm happy to answer any questions.
Any questions for Ms. Smith? Any questions for Ms. Smith? Mr. Crossman, I might prevail on you as to when the Secretary of State can provide that information upon an investigation. Just to make sure that we got it correct. Thank you.
Thank you, Mr. Chairman. So the information that is held by the registered agents, the Secretary of State can receive in an audit. The audit can release that information to a law enforcement in conjunction with a criminal investigation, not a civil investigation. So we can release it to law enforcement if there is a criminal investigation. I do not believe we can give it up for any other purpose.
Okay, thanks for clearing that up. Thank you, Ms. Smith. Any questions? I don't see any more. Thank you, Mr. Laycock.
Thank you. Thank you, Mr. Chairman. I've got about half a page to read, so I'll move pretty quickly. And once again, we're getting back to the question on deed theft. So Chairman, for the record, once again, Tom Laycock, AARP Wyoming. I appreciate you taking the topic on. AARP has a strong focus on fraud prevention. I find myself learning about deed theft right now alongside the committee this interim. Luckily, this is not a new topic for our organization. AARP has been partnering on the issue of deed fraud nationally for years, working with groups such as the American Land Title Association, Mortgage Bankers Association, National Association of Realtors, and others. With these groups, a model bill has been released to help states prevent, detect, and respond to deed theft. I'd be happy to share the model bill with the committee, should the LSO and yourselves request it. A very short summary, it offers preventative measures such as allowing recorders and clerks to reject suspicious documents, defines trusted submitters and enables recorders to flag and report potential fraud, requires a free notification system to alert property owners when documents are recorded against their property, and optional alerts. We also see the bill creating penalties for impersonating our notary, strengthens controls over notary seals, and requires unique traceable notary ID. Finally, it encourages stronger penalties for deed theft, forgery, and fraud. Victims are allowed to recover compensatory damages, punitive damages, and attorney fees. In addition to this, Senator Landon asked about other states or compacts that are being done. In addition to this particular model legislation, we know the Uniform Law Commission is working on something, and they should have something done by next summer. AARP is a part of that as well. So we've seen interest in the concepts such as the ROC, the title freeze. Very interesting concept. We like the concept. We feel it can be a strong tool for the fight. We see it as similar to what we do when we tell people to make a freeze on their credit. Calling TransUnion, Equifax, putting a freeze to make sure people cannot open a credit account in your name. Now, we also understand that deed fraud may not be common in Wyoming thus far, but we've actually seen this New York State open an Office of Deed Fraud. Texas Legislature also recently held a special session on the topic, so it is getting some traction. We find that fraudsters target homes with substantial or completely paid off equity because they yield the highest fraud payouts. Vacation homes and properties belonging to vulnerable adults, such as those living with a loved one in a nursing home, are chosen precisely because these owners are less likely to notice discrepancies in their property taxes or municipal notices. In fact, a 2025 National Realtors study suggests just 12% of deed fraud occurred against owner-occupied homes. So right now, we don't have a lot of safeguards in Wyoming against deed fraud, but understand we appreciate you taking up the topic, and you have a willing partner in this battle in AARP. So with that, I'd be happy to answer any questions.
Thank you. Committee, any questions for Mr. Laycock? Senator Landon?
Mr. Chairman, I'll hurry.
Notice one of the older guys is going to ask a question of a.
Yeah, thank you. I
Appreciate that.
I'll keep it brief. I appreciate the opportunity. Mr. Laycock, I wanted to just throw out something for the rest of the committee. A couple of years ago, we lost my brother. You and I have talked about that a little bit. He was the victim of fraud, several thousands of dollars. But I wanted to say that what we do here matters. A couple of years ago, this committee sponsored a bill working with our banks and our credit unions, and you testified in favor of that bill because of the protections that it would provide, and it did. My brother actually had been convinced by the fraudulent people to put them on his account. And he went into the credit union down in Rock Springs, and those fine folks, in part because we gave them the ability to do so, put a freeze on his account. Otherwise, he wouldn't have had a penny at the end. So anyway, I just wanted to share that this fight against fraud, this committee can make a difference.
Mr. Chairman, just one.
Hold on, Mr. Laycock. You know, that was my bill originally. Mr. Laycock.
Just one last thing to mention, you know, it's election season. We're doing conversations with candidates from U.S. House all the way down to dog catcher in Hawkville. And what we're doing is we're going through our member surveys. And the first, what we're finding is people are interested in pocketbook issues. And number two, for the Vital Voices survey, as well as our member survey, is finding a candidate who can protect them against fraud and scams right now. That is popping in a big, big way. So this is a great topic to get behind this time of year.
Any other questions for Mr. Laycock? Mr. Laycock, you mentioned a uniform act. Is there a name on that act?
Thus far, no. We do have a model act that we work together with a number of other organizations with. I'm happy to submit that to you folks or LSO or anyone else that'd like to look at it. It's a little bit different than what we're seeing in the ROC. The ROC tends to be more consumer-based. The model act that we've got seems to be a little more systemic. And so I'm not sure it's an either or thing. It could be an and.
Okay, let's go to Representative. Go ahead.
Thank you, Mr. Chairman. And just real quick, is there some merging of what you heard in the ROC proposal and the proposed legislation you have? Is there some merge of those that would make sense? I just wanted to get a feel for that. Thank you.
Mr. Laycock.
Representative Locke, Senator Case, I very much appreciate the question because just in looking at the two, like I said, I don't think they're mutually exclusive. I think there could be some potential merge or some working into this. As Representative Gugelmas said, this is the first time we've seen the idea of a freeze early on that a consumer could put on their property. We have a little bit of concern with being forced to be in person to get that released because, you know, we know people own property in Florida, own property in Arizona, live in Wyoming. That could cause a few complications, as it were. But I'm not sure that they have to be mutually exclusive. This particular model legislation is quite a bit smaller in terms of page length, and so I don't know whether you can pick and choose some from here or there, but we're supportive of the concept of the freeze.
Anybody else from the committee? Committee, should we have Mr. Laycock provide the model legislation to us? Thank you, Mr. Laycock. We appreciate that.
Thank you, sir.
Who else wishes to address the committee? Who else? How about then we shift to public comment on all the topics so far? Is there any people that want to make public comment on topics we've heard through the fraud discussion? Yes, sir. Mr. Rowland, right? You gotta
How
have
about a microphone?
Yeah, get her close to.
We'll get
Thank you.
it. We'll get it. Good afternoon, Chairman Case, Chairman Knapp, members of the Joint Committee. My name is David Rowland, and I'm here representing my own interests. In 2019, I launched a privacy product called the Red Pill. Within weeks, 4 major commercial banks responded by canceling or freezing 7 lines of credit. 2 business lines, my wife's 3 store cards, and 2 personal credit cards. Our business bank also seized all incoming merchant sales and deposits, applying them against our reserve line. Despite having no derogatory information on our credit reports, my FICO score plummeted from 800 to below 650. These events unfolded in just 4 weeks. I share this because the government is not always benevolent and can misuse beneficial ownership information filed under the Bank Secrecy Act to punish individuals and their families. Last year, while domesticating 2 companies to Wyoming, I carefully reviewed the statutes regarding registered agents, corporate forms, and especially the LLC Act. I searched for any meaningful data privacy protections. Other than standard commercial limits on public data, I found no personal data privacy policy. There was nothing to enable machine-readable public records or establish non-reputable identities. When legislatures encourage lawfare or co-sponsor bills like the Senate File 82, which intends to pierce the corporate veil, requires third parties to collect beneficial ownership information, exposes registered agents to liability, and places thousands of Wyoming family trusts at risk, enough is enough. Stop fraud is a compelling mantra, but it achieves nothing without careful implementation. FinCEN's approach of pressuring financial institutions through KYC and AML enforcement has become a passive-aggressive tactic that effectively debanks legitimate LLCs. In the age of AI, tools are already being built to profile and cross-track business owners based on fraud patterns and characteristics. And while these tools may help to expose suspected crime, my greater concern lies with small office, home office, and residential entrepreneurs, those without brick-and-mortar locations, who legally sell content or digital work products through e-commerce. These are the legitimate operators who will be denied banking services, harassed through excessive scrutiny, swept up in guilty until proven innocent actions, and potentially destroyed by overzealous enforcement. In response to these failures, I've documented my research and developed concrete data storage and protective methods that achieve the desired goals without the heavy-handed approach of Senate File 82. I respectfully submit this document to the committee and have placed it in the public domain. Any identification that can be repudiated opens the door to fraud. The primary solution for the state is to establish primary authority that is non-repudiated. That would be something that is a record for each basically person or entity that's dealing with the state. I ask you to challenge Blockchain Committee to take action on private data privacy policy, to push toward machine-readable data and save the LLC with applied self-sovereign identification. Thank you. I stand ready for questions.
Questions for Mr. Rowland? Questions, Mr. Rowland? Come on, Representative Yin, you're the only one that probably even understands this. Ask something smart.
Mr. Chairman, I was trying to go home.
Yeah,
Anybody else?
it's fine.
We're going to need more help, Mr. Rowland, so,
I'm with you. I'm here.
okay. Thank you very much for your testimony. Anybody else have testimony on the fraud issue or comment on the earlier bills? Any public comment whatsoever on that? Anything online? Okay, committee, let's just survey this. Remember, it's only 11:30 in the morning, so yeah. So we heard from the Secretary of State's office. House Bill 125, which was Representative Lucas's bill. We could dust that off and consider it next time. I'm going to set aside for the moment the unlimited authority for the Secretary of State. Third bill that the Secretary of State proposed was to take a look at Crago's bill. We've heard that was Senate File 82. We've heard suggestion from at least two groups, the Trust Association and Mr. Pope. I think that needs to go to a working group potentially. We heard considerable discussion of deed fraud. We did get a presentation from Mr. Representative Gugelmoss about the ROC Notice Act. We heard certainly presentation about the need for the Secretary of State's office to have software upgrades, and there's a possibility that we could support that effort with a bill. We heard from Representative Larson about House Bill 104, but the indication was that's not quite ready, and they're going to get us more materials at our next meeting. And we had Mr. Pope supporting the idea of maybe putting all of this into a working group. Mr. Rowland, I'm not quite sure what we're asking there, but I think he would be part of a working group if you want. I think he's proposing that. So committee, that seems to be the menu that we have. Could we agree on having House Bill 125 prepared for Representative Lucas's bill prepared for the next meeting?
So moved.
Got a motion? Got a motion and second discussion?
Mr. Chairman.
Representative Yen?
Yeah, Mr. Chairman, I'm generally okay with it. There's one thing I would like the committee to think of, because I think the bill said if any board member is found guilty of fraud, but if they're found guilty of fraud with nothing, that had nothing to do with the company, is that something where we would want the Secretary's office to dissolve every company that they could ever be a board member with? Something to think on the back of the head. I'm fine with just drafting language as is now, but would ask people to think about what that would mean.
Okay. I think that's fair enough comment. So what we'd be doing is having that bill drafted. It's already drafted. Have staff dust it off for the next meeting of the committee. All those in favor signify by saying aye.
Aye.
Okay, any opposed? Okay, that is carried. Larson is going to get back to us on the fraudulent filings. With respect to deed fraud, the concrete thing we have on the table is Representative Gugelmoss's proposed ROC proposal. I don't know if that's easy to put into a bill or not, or if it could be shorter, but would anybody like to address that? Could go to the working group too. Representative Block.
Yeah, Mr. Chairman, thank you so much. And I'm in favor, whether it's that specific bill or whether it's a discussion with what Mr. Laycock maybe offered up, or maybe taking a look at both of those. But at the end of the day, I would ask for at least drafting of a bill along those lines, because I do think this is absolutely a critical issue. And I can just tell you that I've had a number of constituents bring this up, very concerned, being in this technical space, not directly related to title fraud specifically, but I can tell you, as everybody in this room knows, the sophistication of this is increasing at a blistering pace, especially with AI. And so I think it's critical that we move on something. So I would just ask that whether it's the ROC bill or something else to work with, we want to I would make sure we move something like that forward. Thank you. So I would actually move we maybe do a draft on the ROC bill with the LSO to give us an anchor in the ground on that one to open the discussion.
We do have a motion.
Discussion.
Yeah, let's have discussion.
Mr. Chairman, thank you. And I would have seconded with a couple of caveats. I'm very concerned about the length of this proposed bill. And the good representative picked up right away on it as well. I honestly am not sure we can carry a 100-page bill into the session and have success with it. So that's my concern, Representative, is how can we get something in front of the committee that we can lift and get started with, maybe follow up the following session or whatever. I do think it's important though, and that's my only caveat, is how can we get it pared down?
Follow up to that.
Go ahead, Senator Duckstate.
Thank you, Mr. Chairman.
I have those concerns too about the length. As you were walking into this, though, you mentioned the Laycock proposal as well. Are you wanting both of those as part of a work session, or your motion only mentioned one? Your thoughts, if we could, please, Mr. Chairman.
We'll just time out in the middle here. I think Mr. Laycock's going to get us a draft of something, and we haven't seen it yet to be able to authorize it to be drafted for staff. Can I ask, I was hoping to hear from the clerks on this one. This is the proposal that Representative Gugelmoss made, the rock proposal. I don't know that if you actually saw it, Ms. Freaks. Appreciate your help. Have you thought about the implications of this within your office? Is it potentially doable? Do you understand it?
Mr. Chairman, Julie Freeze, Fremont County Clerk. I'm not sure I said that before, sorry. I had worked with Representative Guggenmoss a while back on some options, but I had not heard this one, had it not come to me on this one. I was going to grab I assume there's a handout back there that I could take back to the clerks. Certainly we would want to weigh in on that, but right now, without not seeing it, I would like to review it and get it to our committee.
And as I understand it, it's a kind of a preemptive filing that puts on your property that it's a red flag that when someone tries to file, it has to be done by the owner in person. And just conceptually, is that something that we could do?
So, Mr. Chairman, we're allowed to record anything. We keep, again, filing and recording. So recording, we can record anything that meets the criteria of the statute, grantor, grantee, acknowledgement, basically. And so people bring us all kinds of weird things that we, as you heard with the frivolous filings, that we, if they meet the criteria, we'll record it. Because all we are is recorders. We're not going to look at it and view if it's accurate or not or any of that stuff. So to record something like that, yes, we can certainly do it. Again, it's permanent. So if it has an expiration like your mortgage does and nobody in our office cares, that's fine, I think. If it's something we have to bird dog or we have to send notices that I thought I heard from Mr. Guggenmoss that there was nothing on the clerks that they had to do. I thought that if it expired, it just expired. So if I heard that wrong, that would be something we would want to look into. But as long as the clerks don't have to figure out if it's accurate or not or any of those things, it seems like it is something that, again, we could look at it and see if there's any part of that that may not work for the clerk's office.
I think to clarify, maybe could you shut your microphone off for just a second? Yeah, maybe to clarify, I think Representative Gugelmoss was open to the idea that at the end of the 7-year term, there would be a notice that would be sent to the person that did the original filing. So that might be a burden if we went down that road. But what this does is it essentially freezes the property from the ownership changing unless the original owner appears in person. So that'd be the enforcement that your office would require. You'd have to verify that person.
Mr. Chairman, so we have those instances with titles, for example, and someone passes away and we have to go through some processes. A lot of people aren't happy with us with whatever the laws are. That's just something we have to handle. So there will be people who will be mad that they have to come back and do something. And it's usually not the person who put it on there, but maybe after someone is no longer able to take care of themselves or after they die and it's left to a family or a guardian or something like that, and they don't live in the state. I can see that they might be irritated at the fact that they have to come to us in person if they live now in Florida, for example. We are used to saying this is the law. I don't make the laws. I just have to follow them.
Talk to the legislature. Here's
That's
his
exactly
number.
what we tell them.
Representative Landon has a question.
Ms. Freeze, thank you. Any concern on your part that kind of instrument would not consistently show up? In other words, if you red flag that deed, any concern on your part that somebody still might be able to get to it? That's the purpose of the act, is to try to lock that thing down. Do you have the capability electronically or otherwise to do that?
So, Mr. Chairman, Senator Landon, again, I don't totally understand the process. So if it's filed, then am I supposed to know that another piece of document is not to be recorded against? Maybe that's the part I don't know for sure. And if that's the case, again, we aren't researchers, we are recorders. I take your money, you put it there, it's there for you, not for me to follow. So I think if that's a problem where I have to know, I don't know how to mark in a recording. Okay, so you record today, and then at the end of the month, we upload to they're digitized pretty much across the county. I think there might be one county not. So then we send them to the archives. How am I going to, I mean, in my system, I may be able to see that, but then how do I continue to, I can't mark it. I'm not sure. That's what I'm trying to say. It's not like I can take out a piece of paper and go, hey, this is no good anymore, or don't touch this one. I'm not sure how I would know on the actual document or how we would know that, or if it's not up to us. That's what I'm not sure about because I haven't read the bill myself.
Mr. Chairman, that is exactly something we're going to have to think about as a committee as we work through. Thank you, Ms. Freeze. I worried that it's not like you can just stamp that deed, with a big red rock notice. I just want to assure ourselves that that deed is covered for the next 7 years. So 6 years from now, could you go to that deed and know that that still has a rock notice on it? That's going to be the hinge point, right?
And again, Mr. Chairman, that puts us into the searching part of that and knowing, I mean, when people want us just to research something for them, we tell them, if you're asking me for, how do you find this deed? We'll try to help them. But if you're asking us for a bunch or following the chain of title, that is not our job. That's what a title company does. You don't want us to do it because we don't make enough to be that person, so.
Yeah. So Ms. Freese, I think the bottom line here is that, how about shutting that off? For some reason, it interferes with, this is to say that you can't make any subsequent filings on that with change of ownership without having the original owner appear in person. So your system is going to have that come up and you're going to have to figure that out. But maybe we're reading too much into it. So I think the committee, we're about to vote on having something drafted, so we're going to learn more. We don't have to settle everything now. We appreciate your input.
Yeah.
Representative Yin.
So, Mr. Chairman, two things that I would want if we go forward with this motion. One, I would ask if Representative Guggenmoss comes back to the next meeting and brings at least one organization that would say that they would recommend this tool, because I don't want to put a 100-page tool in our statutes if no one's going to use it. I want to be assured that someone else thinks it's a good idea and that they would recommend to their clients that they should use it. Number two, I would also want us to think about what would happen if someone files a fraudulent rock notice and locks it for 7 years. Because again, the clerk is asked to facially just accept anything that looks like a facially accurate rock notice. But then it gets blocked for anyone else. So if I'm a member of a trust and I want to block any of the rest, I want to be a minority and block the rest of the majority of the trust from doing anything with the property, just file a rock notice and see what happens, and just to say that I was doing it legally. So there are definitely things that we should think about. It's going to be a big lift no matter what, but I only want to do the work if we know people are going to use it. Thank you, Mr. Chairman.
All good points. Josh, Mr. Anderson, I'm going to look to you. Have you taken a look at this bill, maybe in a broad sense?
Very high level, Mr. Chairman. Yeah.
I wonder if it has to be this complicated. And I don't know that it does. And I'm wondering if in our motion, we could allow staff to streamline this if it can be streamlined. Because it seems like it's a little bit heavier than the concept. So just with that, So, yeah, Representative Locke.
Yeah, Mr. Chairman, thank you. And yes, and I agree with the concerns of the size. So maybe it's more of a conceptual along the same lines of a locking mechanism that might be available and maybe a more simplified way of implementing that would be worth considering. And so I would like to at least amend my motion in that direction because I hear your concerns loud and clear and agree. Thank you.
Okay, so basically we have a motion to have some kind of legislation along this lines drafted, and staff has ability to maybe streamline it if they feel that is appropriate. Anything else? All those in favor say aye. Any opposed? So we've got that one. So that is two. What do you want to send? Do we want to do a working group and let them chew on a few things like the Crago bill and I think Mr. Pope wanted to work in on that and possibly Mr. Rowland. Who's speaking for the Secretary of State? Looks like you're the last man standing, Mr. Crosman. Would a working group be organized out of your office? Take a stab. We won't get you in trouble. What would your opinion be about a working group?
Thank you, Mr. Chairman. I think a working group on these issues would be excellent. However, I don't want to presume that our office should take care of legislative duties. So I think it should still potentially be run out of the legislature. But I would be happy to attend and be on such a group. Yes.
That was good deal. You were clever. You were very clever. Well done. So would anybody in this committee like to lead a working group in this area? Anybody in this committee like to lead a working group? Does the committee want to have a working group? Okay. Senator Landon.
Mr. Chairman, this is a pretty difficult few weeks, to stand up a working group. That's the hesitation on the panel. Sounds like Representative Lucas wants it though. So by golly, I wish her good luck. That'll be great.
Well, we certainly can accomplish something. To have folks get together and talk about the ins and outs of Senate File 82, which was the Crago bill, about getting more information from the registered agents, as well as maybe talking about the unlimited powers of the Secretary of State. I think that needs to be worked a little bit, and we heard concerns from people. So could we put that in the working group as well? And maybe other suggestions that might come out of the working group. And I'd be happy to hold a couple of Zoom meetings, and you're all, and I'm going to require you to come. No, but anybody would be welcome to come. And Mr. Crosman, I'll work with you on that. We'll figure that out. And people that want to participate, it'll be open, and we certainly can do that. Maybe that's a good one to put the insurance issue in. Is that, Ms. Smith, would you be willing to help with that? And that's the issue of when can you get information from a registered agent? We might as well put that in there, absent court order or subpoena. Okay. All right, well, we can do that. What about a draft bill with respect to the budget request of the Secretary of State? I kind of think a bill might carry some weight if it came from, we get $30 million a year, rough numbers, off of our corporate hire. 60 now. It's gone up. If we have to spend $3 or $4 million to make the system more fraud resistant, we should do that. Wyoming should make that investment. So
I'll move that.
let's move it, and let's leave the number as a placeholder, but we'll get some language and we'll do it as a bill. We can also support a budget amendment, but I think that's money well spent. We got a motion second. All those in favor say aye.
Aye.
Okay. Anything else in this area? Senator Boner, and I was told that you don't come across online very much. Got to pull that closer.
Okay, very good.
Yeah.
All right, thank you, Mr. Chairman. So just got word that the Uniform Law Commission is working on Deed Fraud Uniform Act as well. So I'm not sure if that's something we may consider for our next meeting. So that's a separate group that's made up of, it looks like former Secretary Buchanan, Judge Buchanan, and Scott Meyer, a few others. And so they are working on something on the deed fraud as well. I'm not sure if that's something that we need a working group. Sounds like there already kind of is one, but maybe something to consider for our next meeting and see what they may have.
Senator Boner, could we do parallel paths that if the Uniform Law Commission has something to present to us, we take them up? And if they want to participate in the working group, they're welcome to.
There you go.
Is that parallel path? Would that work with everybody? Okay, good. Anything else on the area of fraud? We're already to noon. Just think about it. So with that, let's take up our next topic, which I think is is it the CPA? I think this won't take long, you guys.
And Mr. Chairman.
Oh, wait, it's the Insurance Model Act. I'm sorry. Yeah, Insurance Model Act, then CPAs. Don't worry, didn't mean to get you excited back there. I hate when the CPAs get excited. It's crazy. It's
Mr.
Representative Yen.
Yeah, Mr. Chairman, so just briefly, for Mr. Rowland's bill, I will bring it up with the blockchain select committee when we're in Sheridan. Hopefully, Mr. Rowland will be able to make it, but if not, I'll bring it up with him.
And you can cross-fertilize with the working group if you so choose. Were you going to present the Model Act?
Mr. Chairman, I don't have anything on the Model Act.
Oh, okay.
I don't have a draft on that one, Mr. Chairman.
I thought I sent it to you, but.
I have a draft on the CPA one.
Okay. Well, then we don't have I thought we did have a draft on the Model Act, but you guys are familiar, you're both familiar with the Model Act, so help us out. And this is a Model Act from the National Conference of Insurance Legislators, which Wyoming is now a member state of that group. Yeah, it is very common that we take up Model Acts. We usually get them from NAICS, which is the National Association of Insurance Commissioners, but they're two separate organizations with parallel paths sometimes. So who would like to lead us off? Commissioner, welcome. Thanks for being so patient.
That's fine. Mr. Chairman, committee members, I'm Jeff Rude, the Insurance Commissioner. I was presented with this NCOIL Model Act through Senator Case and through the discussions with Ms. Smith. I'll let her answer any questions of it. She is in essence bringing it. We have talked with her about it, and we've talked with agents and we've talked with industry. I think we're close to coming to a really nice place with the bill. I think we might want to shave some things off and, you know, maybe pare it down in a couple places, but we've discussed it, and I think I'm pretty confident that, you know, should you bring this as a bill, we can all come on board with a consensus. And so with that, I will leave it to Ms. Smith.
Good testimony, Commissioner. Ms. Smith.
Thank you. Marion Smith with the National Insurance Crime Bureau. This Model Act was recently updated this past fall. Mr. Chairman, you were at that meeting. So this is the most updated fraud act from NCOIL. And essentially what they included in it, which updated it, was a definition of fraud as far as inflated billing. And so there were some updates to what constitutes fraud. You might recall 2 years ago, House Bill 71, we brought a model, or not a model act, we brought a mandatory insurance fraud reporting bill before you. It was never heard in committee. It needed a lot of work still. We, in the meantime, in between there and then, we've worked very closely with industry. One of the issues which we agreed with and we believe are resolved in this Model Act is the issue regarding immunity. Civil immunity for people reporting, so that if I think that there's fraudulent activity going on, I should be able to report it through the state insurance commissioner or through our organization and not feel like they're going to come back and get me for, you know, liability kind of issues. Same with our insurers. They need to be held immune too from suspected fraud reporting. So the House Bill 71 needed some more bones on that immunity language. It wasn't ready for prime time, but Since then, we do have a new model act. It's updated. We believe that we could probably, with the help of LSO, get you a very robust fraud reporting bill. Wyoming is only one of 2 states in the entire country that does not have mandatory fraud reporting for insurance. And it's time that we crack down on fraud reporting. We've been talking about it for the past couple hours. Let's have it in our insurance statutes, recognized as far as mandatory reporting. It's not going to cost the state anything. They don't have to stand up a fraud bureau. There are about 7 states in the country that don't have fraud units, but they do have mandatory fraud reporting. And it's done very easily through the department, through our organization. We share data and analytics very easily. Even in the days of consumer data privacy, we are able to do so. So if we see insurance fraud trends, we can call the commissioner, we can work with the insurers, and so it's high time that Wyoming just fill in the block as far as not having mandatory insurance fraud reporting legislatively in our statutes. And I'm happy to answer any questions.
Thank you very much, Ms. Smith. And everybody, in your packet, there is a copy of the NCOIL Model Act. It begins on page 209 of your e-notebook. And I knew I supplied this. So, and you will note that it doesn't necessarily follow Wyoming drafting conventions in the sense that it does begin with findings, and most of the time we're not too big on findings. So I would hope maybe in a motion we might allow staff some direction with respect to findings and other conforming amendments. But Ms. Smith, I think you've done a great job of talking about it. If we see it in proper Wyoming form and we get it appropriately noticed for practitioners and consumers to see it, I think we could possibly begin to work on it next meeting. Would that be your plan, Ms. Smith?
Yes, thank you, sir.
Okay. Let's see if there's any public comment on the concept of taking this up. Is there any public comment on the NCOIL Model Act?
Hello.
Hi.
I'm Amy Hendrickson. I'm with the Association of Wyoming Insurance Agents, and we are supportive of this effort. We agree with what was said about the immunity. One other area, though, and I appreciated what Marion said about the fact that not all states have a anti-fraud unit. We feel that the department can probably address some of this. The NCOIL Act does require an anti-fraud unit to be established in the Department of Insurance, but that raises some concerns for us with regard to cost and the impact to the industry from that regard. But otherwise, we are supportive of the legislation and addressing insurance fraud. It does have a tremendous impact on the cost of premiums in the long run. Fraud does increase premiums, and that affects obviously our customers as well as the companies too. So I'm here to answer any questions.
And thank you so much. And did you say your name is Smith?
Amy Hendrickson.
Hendrickson. I'm so sorry.
That's okay.
That's a great.
With the Association of Wyoming Insurance Agents.
You and I have visited.
Yes.
By email, and I appreciate you. I'm coming up to see you in Cody.
Yes, you are. Thank you.
Yeah, thank you. Questions for Ms. Hendrickson? Any questions for Ms. Hendrickson? Thank you very much for that testimony.
Thank you.
Ms. Wolf.
Good afternoon, Mr. Chairman, members of the committee. Catherine Wilkinson here on behalf of 2 clients, actually, to comment on this. The first would be American Property Casualty Insurance Association. Would echo the comments of Ms. Hendrickson. We are generally supportive of the NCOIL Act. I believe just for motion purposes, so should the committee decide to move forward with a bill draft of this, Section 11, I believe, is the one that everyone was referencing in terms of creating the fraud unit. There is some concern there with more mandates. Most insurance companies do have fraud plans, but if you're looking for a motion draft, that's the specifics. We are generally supportive of it, but we'd love to have a conversation if you do move forward with the bill draft about specific provisions of that. Immunity provisions, again, reducing the litigation risk, ensuring that good faith is in there is critical for us. And then second hat, Mr. Chairman, on behalf of Delta Dental of Wyoming, they also stand in support of this because currently there is no recourse if fraud occurs and no way to report it. So we would look forward to working with the committee should you decide to move forward with this. And with that, I'd stand with any questions. Thank you.
Thank you. Any questions for Ms. Wilkinson? Ms. Wilkinson, with respect to the regulatory requirements of Section 11, one of which is require carriers to establish a fraud unit. Is that correct? So we would eliminate that. Maybe there would be some substitute language that carriers should respond to fraud, or I'm not sure what the language would be, but it's short of having a unit. Would that be acceptable, you think, possibly?
Mr. Chairman, yes, I think it would be acceptable. I think that we just need to take into account that we have a very small insurance department here in Wyoming. I believe they have 27 employees. And so I'm very happy to work with the committee, but just having that if a more Wyoming language to not increase the burden on the Department of Insurance and then increase or decrease rather the amount of money that's going to go to the general fund from the premiums that are increased to fund those positions.
Perfect. And it's a shift to you, Commissioner Rood. Thoughts on what would work for Wyoming?
Mr. Chairman, my thoughts initially were I would suggest to all of the parties, I'm okay with if we get rid of that entire section. I don't feel that my office is in the position to tell a multi-billion-dollar insurer what their anti-fraud policy should be. I assume that they have one as a multi-billion-dollar insurer to begin with. If it was given to us, if the legislature wanted us to take that role, I would end up hiring a vendor to do it and probably having those vendor costs charged to the insurance company they're looking at. I don't necessarily want that. I just don't think we need it. We have a very a small handful of domestics that we're responsible for directly. These other companies are domesticated in other states, and they're being taken care of with their larger departments in their larger anti-fraud units there. So I just don't think it's necessary, and I just don't think it's our role unless the legislature wants to make it so.
Fair enough. So committee, keep in mind that might be in our directions to staff and our motion. Anything else, Ms. Wilkinson? Thank you all. Anybody else like to testify on the insurance fraud bill concept? Anybody else? Anybody online? Nobody online? Committee, you've heard the proposal. Can we have a motion for a bill draft? Senator Landon?
Mr. Chairman, I would move that we have the NCOIL bill drafted absent Chapter 11 and request that Mr. Anderson and the troops pull it into Wyoming form and have it ready for the second meeting.
And we've got a second by Dockstader. Would it be friendly to deal with the intent clause, which are, I mean, we've had more intent clauses in bills, but I think it doesn't really help us.
Yeah,
it binds us down the road. So you can eliminate the intent clause too as part of the motion. That seems to be friendly. Any discussion? All those in favor say aye.
Aye.
Any opposed? And if you really want intent clause, you can put it back in when we get down there. Yeah, if you think it's important. For 30 years, we've fought intent clauses, and now they kind of sneak back in. And I'm not sure they're as helpful as people think they are. Okay, so we're taking care of that one. Now it's time to stand and cheer for certified public accountants everywhere, every place. Yeah. And it fits into the overall framework of ascertaining fraud and dealing with fraud. So here we are, and we have our very own Landers, Sarah Sweeney.
Good afternoon, Chairman and committee. I'm not sure that I can follow that up, so bear with me. And I know you all want to go home, so I promise to be brief. Thank you for the opportunity to speak today. As you heard, my name is Sarah Sweeney. I'm a CPA in public practice here in our great state of Wyoming. I'm currently the president of the volunteer association, the Wyoming Society of CPAs. I'm here in support of the House bill addressing certified public accountant qualifications, which modernizes Wyoming's CPA licensure framework to better align with today's accounting profession while still maintaining strong professional standards. I'd like to quickly highlight the purpose of the bill. At its core, it does three things. It modernizes CPA qualification pathways. Second, it modernizes the experience requirements. And third, it clarifies and streamlines interstate practice privileges. These changes ensure that Wyoming remains competitive while still protecting the public. Next, I just want to briefly summarize the key provisions. The modernized education pathways. What this does within the bill is it keeps the two current education pathways, but it also adds a third pathway. This recognizes that multiple education routes are needed. Candidates can opt for a bachelor's degree, 150 hours of education, which would be a bachelor's degree plus 30 extra hours, or they can complete a postgraduate degree. It also tailors the experience requirement to match with the education. The bill maintains the necessary experience requirement of 1 year of experience for the 150-hour folks and also graduate candidates, but it expands to offer a 2-year experience requirement for those who have a bachelor degree only. It also refines mobility and practice privileges. CPAs licensed in other states can practice in Wyoming without additional licensing burdens. This bill modernizes the language and the criteria to reference individuals rather than being state-specific. The policy rationale for this is first, workforce pipeline. As we all know, Wyoming struggles to bring in and retain professionals. CPAs are no different. This bill reduces the barriers to entry while still maintaining high standards. It helps ease hiring challenges without sacrificing our qualification standards. A couple of notes on this issue. The average age of CPAs in Wyoming is currently 51 years old. This indicates we've been unable to adequately fill the pipeline with new CPAs. We believe this bill will help to remedy that problem. Wyoming also struggles to attract or retain bright young professionals. It's imperative that we're on a level playing field with our surrounding states in terms of available pathways and licensure requirements. This is about keeping Wyoming competitive in attracting and retaining accounting professionals. Next is national alignment. This bill serves to align Wyoming with evolving licensure models across the country. Without this bill, Wyoming faces inconsistency with national standards. We are one of the last 3 states to pass this important legislation. And you have a map, I believe, in your handout that shows this. Passing this legislation will keep Wyoming competitive and support Wyoming businesses operating across state lines. By coming into alignment with other jurisdictions, we will be welcoming mobility into our state while retaining local enforcement authority. Public protection will be maintained. This bill in no way lowers the standards for CPAs. Education, examination, and experience requirements will remain in place. The bill stands to modernize the available pathways, but the core competency requirements remain fully intact. Every safeguard that protects the public today remains in place under this bill. Before I close, I brought with me 3 models today of how important this bill is to Wyoming and business in Wyoming. I'm going to ask my 3 models to stand up really quickly. Example number 1 is Marty Welling. Marty grew up in Wyoming. She attended UW. She graduated this May with a bachelor's degree in accounting. She graduated with 120 hours. Therefore, she will only be able to obtain her licensure after gaining 2 years of relevant work experience. But that is only if this bill passes, allowing the third pathway. My second example is Josh Barron. Josh grew up in Washington State. He graduated from Utah Valley University this April with a bachelor's in accounting. He graduated with 150 hours. He may opt to gain part of his year of work experience and his licensure in the state of Utah. If after that, we can woo him back to Wyoming to start his career, this bill would allow him to seamlessly make that move. And I'll let Joseph off the hook, but Joseph is in the same boat, and we're trying to keep him here in Wyoming, not let him go back to Utah. Thank you, guys.
Hey, and we're proud of you. We are proud of you. Thank you. Good job.
Plus, we have them here today learning out about our important legislative proceedings. These young people are aspiring CPA candidates. They have all indicated they hope to ultimately live and work in Wyoming as licensed CPAs. The successful adoption of this bill will help them to do that. Without it, they may have to leave our state and pursue their dreams elsewhere. In closing, this bill improves access to the profession, supports Wyoming businesses, and aligns our state with national best practices, while still maintaining strong safeguards for the public. Without these changes, Wyoming risks falling behind other states in attracting and retaining professionals. I respectfully urge your support of this bill. Chairman and committee members, would you like me to go through the bill line by line?
I actually think it'd be good if you went through it. It won't take that long. You don't have to go line by line. You can just highlight the changes.
Okay. I will start on page 2 of the LSO copy. In the first section, and you'll see this a lot throughout the bill where we were referred to substantial equivalency. That language is being modernized to be referred to as mobility practice privileges. The only real difference is that substantial equivalency was an older term that when we were talking about states and trying to match up states, this mobility relates more to individuals than states. So we're just modernizing the language, and you'll see that throughout the bill. On the next page, page 3, again, up at the top, it's the same thing, the substantial equivalence. Then down in section little b, where there's a bunch of language taken out that refers to 2012, that was a section that required to some old grandfathering language. So that related back to a provision that was intended to grandfather in, old people like me and what the requirements were at the time, and it's just no longer relevant under the new provisions.
Would you kindly back up to line 23 on page 2? There's one word, there's an "and" that's struck there at the very bottom of the page.
Sure.
You see the word "and" hopefully your line numbers match ours, but it's.
Yes, they do.
Okay. Line 23 says requirements, comma, and then there was an "and" there that you're removing.
I have to honestly say that seems like an error because.
Okay, Mr. Chairman.
Let's find the man that made the error.
That came from LSO, and that was it's a cleanup just because it says "and further educational requirements and not exceeding." So I think that was a cleanup that got put in through our review process.
Okay, so sometimes this happens, and it's okay. We're not trying to pull a fast one, and LSO looked at it and said, they actually look at this stuff. They really do. And they decided that was superfluous or confusing. So you need to verify if it still works or not, and you'll have to let us know.
Okay.
Yeah. And we're going to have to decide whether we're going to vote this bill today or we're going to carry it over. And that will depend a lot on whether it's been properly noticed, but I think it has been properly noticed, hasn't it, Josh?
Mr. Chairman, it was part of the meeting materials, so.
Yeah. So we could vote this as a final bill today, and then we wouldn't have to come back to it. So think about that, and everybody out there, if that's a problem, we could change it. Okay, keep going, Ms. Sweeney, I'm sorry.
So on page 4, the language in lines 5 through 11. Again, I believe that this is just cleanup in the language. It's referring to the college or university, and instead of recognized by, it's changing it to acceptable to. And I should also note, the person sitting next to me is Taryn from the state board. So Taryn, feel free to jump in here. She's probably more the expert on the original bill than I am, so she may be able to clarify questions.
Is Taryn your last name, or? Here, get yourself a microphone. You can stay close to her, but it doesn't matter. What's your last name?
Thank you, Mr. Chairman. I'm Taryn Demers I'm the Executive Director for the Board of CPAs.
Dwars?
Sorry.
Last name?
Demers.
Demers.
Yes, sorry.
Thank you. Please feel free to jump in and help Ms. Sweeney. I know sometimes she needs a lot of help. Ms. Sweeney, keep going.
Okay, so in line 10 and 11, again, this language is just changing or getting rid of the substantial equivalency language, again, that has been deleted throughout the document. And then the rest of the way down and the next page that's underlined, the reason all of the references have had to change is because that third pathway is being added to the language. And paragraph little I is the new pathway, just for reference. And then 2 and 3 are the pathways that were already in place. On page 5, under section big B that starts on line 4, again, it's just a change to incorporate all 3 pathways. The part that's marked out, the 4 years, that was relevant under that piece that I referred to in the very first section that was a grandfathered in section from pre-2012 that's no longer relevant.
And right, we just might take a slight time out here. In terms of, Ms. Sweeney mentioned that Romanets 2 and 3, which are underlined new language in our bill, are the existing pathways. And I think the way the convention works on that is those were repealed and rewritten. Is that right, Josh? So if you look at the repealers, you'll nail those. So just to make sure, and Ms. Sweeney, what we're trying to say is underlying stuff is new language for us. So we're thinking, oh, that's new language. And then you said that's the existing pathway. So it's a little bit confusing. But what we did was we repealed those old sections and we rewrote them. Is that right, Josh?
Correct, Mr. Chairman. So you can see all that repealed language starting on page 13 and 14. Yeah, as Ms. Sweeney noted, you can see there C was 150 semester hours of college and 1 year of experience, which was on page 14. So
got it. So just getting on the same page. It's all fine.
Mr. Chairman, yeah, just it was just done to kind of make it flow better, and rather than doing a bunch of different renumbering, so it was just done that way to make it.
I understand completely, and I appreciate it. I just want to point it out to the committee. Ms. Sweeney, back to you.
Okay, I think we are on to page 6, Mr. Chairman, unless anyone had questions before page 6. And on page 6, again, the only thing that's changing is that substantial equivalency language. Yes. On page 7, again, in the top section, we're again changing the language to get rid of the substantial equivalency language and modernize it to the current language. Same thing again in lines 11 through 15. Okay, on page 8, the change in the middle of the page between lines 7 and 16, that change is happening once again because we've gone from state equivalency to individual qualification. And this section is also intended to make sure that an individual that becomes licensed in another state under the new pathway will be grandfathered in and be allowed to practice in Wyoming if they have obtained licensure under that new pathway in a state that has already adopted that pathway. On page 9, the words "in good standing" were added on line 7. And then on line 8 through the bottom of the page, again, this relates to when other states have already passed this and Wyoming hasn't. So again, we want to be sure that someone who obtains their licensure under another state's laws can come in and begin practicing without delay when Wyoming gets this passed. On page 10, the word subsection was changed to section. I assume that's just because of the numbering scheme. And then on lines 12 and 13, again, it's just the language modernization from substantial equivalency to practice privilege requirements. And same thing, frankly, from lines 15 to 22, we don't have the state language anymore. It's moving to refer to the individual rather than the state. On page 11, the language has, it's just changed from saying, completes at least 150 semester hours to having a degree conferred. Well, so I guess this is changing because, again, we had to move everything down because we're adding that additional pathway at the top. So this section becomes the section relating to a simple baccalaureate degree, and then the 150 hours moves down to big B. Yes. And then a graduate degree on the next page, page 12, moves down to big letter C. And Mr. Chairman, I believe that's all.
Yeah, and everybody, that is the completeness of the bill. There's staff comments on page 13, and they provide all the repealers for you to look at. And you can see that it does what Mr. Anderson had said. So, did you want to weigh in on anything? Do you guys support the bill?
The board currently is neutral. I'm here to answer any questions
Okay.
in regards to facts or anything with the licensure that you guys may have to provide that insight. But the board does not weigh an opinion at this time.
Does the board find it to be a workable proposal?
Yes, this is something that we could definitely put into place into our office without issue.
Okay. Question from Senator Landon.
Just real quick, curious, why is Wyoming the last state on the list to do this?
Well,
Ms. Sweeney wasn't busy enough.
Senator Landon, this is only my opinion, of course, but I think there are a couple of reasons. Number one, Wyoming is a smaller state with not as many resources as some states. So we consciously chose to be not at the forefront of this legislation because we wanted to wait for others to get the language ironed out, pay the attorneys to do what they do, and we wanted to wait and be able to use the language that had been adopted by the majority of the states so that we weren't different. We didn't have to go back and redo anything. So part of this was a conscious decision to be later in the game. The other reason, I believe, is due to the structure of our legislature. Because we weren't able to bring it during a budget year, we had to, we weren't ready 2 years ago. And so the time frame moves out pretty substantially from there.
Thank you.
Mr. Chairman, as a follow-up to that, I heard other schools mentioned here today. Do we need to be doing anything with our own university to track this in closer?
Ms. Sweeney?
Senator Dockstader, that is a very good question. We work very closely with UW. I want to say that there are more students going into accounting, but it's still really rough. I really do think this will help because a lot of students, whether it be at UW or elsewhere, for a variety of personal reasons, either aren't willing or aren't capable of spending that additional year in university. And so by giving them the additional pathway where they get a bachelor's degree and then they go get 2 years of on-the-job experience, we don't think that, is a bad thing in any way, but it will allow a lot more students to go into accounting. A lot of students would say on surveys and things that I just can't afford to stay for 5 years, so I'm going to choose something different. So we hope that this helps not only UW, but other universities as well.
I'm going this way, Representative Webb.
Thank you, Mr. Chairman. My question is I see the effective date is July, I realize we're just dealing with drafts, but July 1st, 2027. And on page 9, it refers back to on March 1st, 2025. What would be the reasoning for a 2-year looking back?
Ms. Sweeney?
Representative Webb, the reason for that March 1st, 2025 date is that is when the first state adopted, well, it's not the exact date, it's a generalization, but that is when the first state adopted this pathways legislation. And so this is related to the grandfathering in, if you will, of a candidate who obtained licensure in another state. Let's say someone obtained licensure in Utah in April of 2025 under a pathway that we don't yet have. This allows us to let them in once we pass the legislation on July 1, 2027. Does that make sense?
Thank you very much. So somebody could be working on this exact pathway right now in Utah, and when this passes, they'd be able to come home. So Representative Lucas.
Thank you, Mr. Chairman. Just curious about the accounting concentration or equivalent. I majored in accounting. Is that the same requirement, or, I mean, how do you determine what a concentration, how many hours is that in coursework? Just curious about that.
I am not sure. I'm going to let you answer.
We're going to let the board do that.
Yeah.
Mr. Murr.
Mr. Chairman, Representative Lucas. So currently we are going to maintain that it is 30 hours of higher accounting courses and then 30 hours of business. So that will remain the same, and that's currently in place. Thank you.
Any other questions from the committee? Any other questions? Let's see if there's any other public testimony on this particular bill. And then committee will take it up. Anybody in the audience wish to testify? And it's okay if you just say Is everybody in favor? You can raise your hand. Look at that, okay? Anybody opposed? How about online? Do we have anybody that wishes to speak? I see Mr. Pope has his hand up. Can we bring him in?
Thank you, Mr. Chairman. Again, David Pope. I'm a CPA and a chartered global management accountant. There are four major issues with the CPA pipeline, and this addresses one of them. I am all for it. There's only one other one that can be addressed legislatively, and that I will be working with my local legislators to hopefully prepare additional suggestions for this committee down the road. But I am absolutely for this bill, and I will stand for questions. There's a lot of history behind it. I actually came into the profession under a similar requirement of bachelor's plus 2 years experience back in the dawn of time. And I think I thought it was a mistake to move exclusively beyond that when it happened. And I think this is a great way to go back to our roots. And so I will stand for questions, but again, those four different issues with the pipeline, this addresses the first one, and I'm thrilled about it.
Thank you, Mr. Pope. Questions for Mr. Pope? Thank you very much. Anybody else online or elsewhere that wishes to testify? Okay, committee. We got a motion on the bill, but first you get a joke. You guys know I'm an accountant, don't you? No, I'm actually an economist. Do you know what an economist is? No, it's somebody that doesn't have the personality to be an accountant. Okay, who now are we moving? We have a choice here. We could kick this bill down the road, but I would recommend that we voted for final passage and we can actually go home and think we did something. We are going to hear 911 because you've been so patient in the very back. But so I would entertain a motion for final passage. Okay, we got a motion. Who did the so move? Was that Boner? And we'll give the second to Johnson. Are there any proposed amendments to the bill? And we still have to go through the legislative session. It goes to committee. So if we find a little hitch, which sometimes happens, we can fix it.
Mr.
So,
Chairman.
yeah, Representative Yen.
Mr. Chairman, for Mr. Anderson, if we move that, so that and it is bugging me a little bit, just a little bit. Why is that third and struck and not the and in the line above it? And does it make sense to just switch which ones get struck?
Mr. Anderson,
So
the and is on you.
Mr. Chairman, so I think the sentence reads, and regulation with the deletion of the and, regulations, oh, sorry. The board shall prescribe rules and regulations which shall include regulations governing educational and experience requirements, comma, and further educational requirements not exceeding 120 hours for the 3-year period to be met. So I think that 120 hours is attached to that educational requirements. So I think that the deletion of the and where it is works, although it is kind of a long run-on sentence, Mr. Chairman.
Call the question.
Let's note that staff defended their and admirably. Any other discussion on that point? Anybody? Okay. Any other issues with the bill? Anything at all? Please call the roll.
Mr. Chairman, this is roll call for 27 LSO 0011, Certified Public Accountant Qualifications. Senator Boner, Senator Dockstetter, Senator Landon, Senator Steinmetz, Representative Brown, Representative Heft, Representative Johnson,
Aye.
Representative Locke,
Aye.
Representative Lucas, Representative Webb,
Aye.
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 So that means that all three of you have got to come back and stay in Wyoming and spend your whole life here. Because we did this for you today, and good job by the board and by the society. thank you all for coming. It's always fun to do this because this actually makes total sense to me. And I think it's a really good move, and I think it kind of corrects a direction you went in the past that wasn't so good. So thank you. All right, 911. You poor thing, you've got to drive all the way to Cheyenne. Well, got rid of that Zelensky guy. He was a so turn that microphone on, and you have to turn that green light on and while you're here.
Chairman Amy Binning with the Wyoming Department of Transportation. I am the Next Gen 911 Planning Coordinator. Mr. Smolinski was the 911 State Coordinator appointed by the governor, and he has moved to another state to do radio operations and coordination for Minnesota. So we are actively looking in YDOT for his replacement, and then we'll see what the governor decides to do for the appointment.
So you want to tell us what you guys are doing with the 911 research?
Yes, sir. So just to report out, as many of you know, the SF 0032 and Senate Enrolled Act 15 was approved by the legislature, and from there came two projects. The GAP Fund, which was to give the Wyoming Department of Transportation $3 million to distribute as a grant that could be applied for. The purpose of it was to give the 911 relief for current operations of a dispatch center. 911 fees that are collected and distributed or reported to the public safety, or sorry, I got too many acronyms in my mind right now. The Public Service Commission. The county clerks report the usage of the 911 fees from January to December of any given year, and they have to have those reports into the PSC by March. And that becomes very important when I relate that information. We did have a question on the grant, because when we helped develop the grant and the notice of funding language, I did put in there that the performance period for that grant was limited from January to December of 2027. I am well aware that the legislation says that the funds have to be expended by 2028 in June. But I have to tell you that 911 funds, they are reported to the FCC annually. And so to kind of keep it cleaner, I put that stipulation in the grant fund operations. Now, if that is something that is not what your intention was, I'm happy to hear those comments. But in the notice of funding, that's how we did it. So we also broke it up into projects with their applications. Now, many of the grants that people apply for, whether it's a federal or a state grant, has a project. Projects allow us to be able to show you exactly where that money was used and for what activities. Now, the 911 legislation is very specific on what they can use 911 funds for. So I replicated that information in the notice of funding opportunity, but I thought it was very important for you to be able to ask me, well, what did we spend those funds on and what was the applicable expenses? So they will have an opportunity to apply for up to 2 projects. We did estimate that 50 to 150,000 would be awarded. Just for your information, there's 30 PSAPs in the state, total of 32 PSAPs. But the reason I don't count those 2 PSAPs is one is in the Yellowstone National Park. It is a primary PSAP that does serve portions of Wyoming, but they do not get directly 911 funds. Park County does give them $10,000 a year because that is the population that they serve that's within the state of Wyoming in the county. And then the other PSAP that does not receive 911 funds but is counted as a PSAP is with the Department of War out of Laramie, Wyoming, Cheyenne, Wyoming, Laramie County. So with those 30 PSAPs all applying for grants, I estimated that 50 to 150,000 would be awarded to each one of them and still meet within the $3 million. Are there any questions on the grant project?
Committee, any questions? We might have to talk about the timing. Can you go over that again as far as the legislation said this, but you guys are doing that? Can you
Yeah.
cover that again?
Yes, and I'm happy to cover it because it did come up this week. You know,
Okay.
there was some questions on it. So I believe that in the statute, it states that the timeline for expenditure is back to, well, I gotta find my little notes here. I apologize.
Representative Weber said 2/30 of 28. Does that sound right? June 30th.
June 30th, that's
Okay.
correct. Yes.
Okay. All right.
Yes, it did say that those funds would be expended by June 30th of 2028. So part of my logic with saying from January to December was because I still have to take in, you know, time to be able to close out those projects on the grant side. And then also, we're checking with the state budget office and also the LSO to see if there needs to be, you know, loosening of the funds. I don't know what the word or the proper wording would be on that, but something of
maybe
the
release.
use of the funds.
Yeah.
Because we will not have them in our budget until October.
So I'm wondering, we could change the legislation. We could change it to be January 1st of the next year or December 31st. We could do that. Maybe we don't need to, but we could do that.
Chairman Case, I honestly think that's what's going to happen is you're going to get probably $5 to $7 million worth of requests for the projects. I really feel that after talking to many of the PSAPs, there won't be money left in their projects to spend after December 31st. There's a lot of need in 2026 and 2027, the funds that were reported to the PSC. There was a $6 million deficit in 2026 and a $7 million deficit in 2027.
So I guess your bottom line point is that money's going to be spent by the end of 27. We don't need to worry about changing the date or anything. Okay, I'll stand on that. You keep going.
Okay. The next project that you guys awarded some money for was a $750,000, and the purpose of that was to do a study. I titled that study a feasibility study based off of the requirements by not only the legislation, but also what you were looking for. When you look at a feasibility study, it's very common that those are done in many states across the United States. And so it was easy for me to identify the scope of work based off of not only your expectations of looking at efficiencies, but governance, equipment, inventories. I also put in there for the statement of work, you know, it's really important to understand how an operation takes place. And the reason I state it that way is because there are MOUs, memorandums of understanding and memorandums of agreement between entities to have a dispatch center dispatch for them. So for instance, you might have a county that dispatches for 3 entities, like the police department, the EMS, and the fire department for their whole county. And then you might have another PSAP that not only does everything in their county, but they do support another county in their operations. And they might dispatch out for 32 entities. So when we're looking at efficiencies of operations, it's important to understand what is the operations and who are the agreements with and what is that doing to support their cost of operations. So I did put that in there as well for a request. But primarily I focused on operations, efficiencies, expenses, and funding. I did ask the proposal company that we had 6, I believe, that supported us with proposals. We did decide on one. We're still working on the contract with that individual. But I did have a conversation with each of these individuals and asked if they would be able to give you a report by end of August 2027, because I know how important that information is for any future developments that you might be considering. And even though we haven't signed that contract as of date, they all have stated that they would be able to produce that kind of a report for you. It's a midterm report. It won't be the final report, as the final project will be completed next year in 2028. Are there any questions?
Understand. Sounds good. Committee questions, Representative Webb?
Thank you. Thank you, Mrs. Banning, for being here. Two questions. I might have just missed one. I'm like, you got the 1.5 million for the 30 times $50,000 for each PSAP.
I estimated that between 50 and 150,000 could be awarded.
Okay.
Because if you had $100,000 per PSAP, that'd be $3 million. But there may be requests for only 50,000. And so then that would give you a little bit more.
Thank
leeway.
you. Follow up.
You bet.
Last year during this meeting, there was the information they gave us had a $5 surcharge in the long run for each telephone line. Just like to know the status of that.
Sure. Well, the study chairman, the study that was requested, I'm hoping will give us some better guidance on how maybe we can fund 911, and not just in the short term, but also in the long term. We know that technology changes. We know that the costs change. Representative Webb, I have to tell you that it's really interesting to me, like, we haven't funded Next Gen 911, the newer technology, right? But I think part of the reason that the increase in costs have went up exponentially is because we're still funding old technology. So there's a circuit that comes into a PSAP, and the old technology is called a TDM circuit. The TDM circuit went up 300% in costs, not just in our state, but in many states. And the FCC passed recent legislation that said, get rid of the old technology, get rid of the old circuits, because you're not maintaining them and you're charging up the up costs. So, I think it's very important for us to get the information that will help you as legislatures to make good decisions on how do we create a sustainable option. And I think that this report, it might be lengthy, but I think it'll help us quite a bit.
Thank you.
So, and just on this point, these private circuits, you might turn off your mic, Representative Webb. Yeah, we used to call them private lines in the telephone business, and they're just a lease line that's dedicated for that purpose. And they evolve. There's a digital equivalent. They used to be analog. And there were ones that were a circuit that was based on one single telephone line. And then there was combinations called T1s, which were 24 lines. Those are the most expensive things you can buy because they're literally tying up a telephone cable or fiber optic cable, depending, from one spot to another. And you have to pay for that, and it's based on mileage. Now, all that doesn't need to be done anymore. It can be kind of the equivalent, telephone equivalent of cloud-based, where that call comes in, but it doesn't have to go through that 20 miles of cable that you have to pay for. So if we get rid of all those private lines, we will save a lot of money and potentially have The other thing about that private line is if it gets cut, it's a physical thing. It could be a circuit based on microwave or something like that, but it could fail. And you're dedicated to that. And to back it up, you have to have another private line that goes somewhere else. In a cloud-based system, you don't need that. And it's a leap of faith, but it really is going to the new technology. And I'm hoping we'll get that and see some efficiencies. But
Yeah.
I also hope we're going to see some efficiencies and somebody's going to have the fortitude to actually stick their neck out and say, you know, Wyoming, you really don't need 30 PSAPs to do the job. And Fremont County doesn't need 2. We're just as guilty. Riverton has its own PSAP and the rest of the county is dispatched by the sheriff's office. And we don't need to. And Riverton can't afford theirs now. They're looking. So I am so hopeful that a path will come forward, and we may need to make incentives to get people to cooperate, to work together, because law enforcement is very territorial. Sheriffs are very territorial. They like to have their PSAPs, but we have more PSAPs than counties in Wyoming. And literally there are PSAPs in the United States that dispatch to a population, one single PSAP as big as the whole state of Wyoming's population. Now, I'm not saying that's a good idea because the geography of Laramie and versus Teton County, and you got somebody on the phone talking to a dispatcher and they don't know it. That's not a good idea. But 30 is not a good idea either. I hope we can maybe cut costs significantly. And do you think your study anticipates that possibility? Are we asking the right information?
So I think the importance of the information that we're asking is because it's very important to understand the operations from a call to the end of call, right? And we did include 988 in that part of the study because every 988 call has a potential to go to 911 first. And so what are those impacts, right? Senator Case, I have to tell you, I had the pleasure of touring Austin Travis County Dispatch Center. They had just combined one dispatch center for all of Austin Travis County. I was up there for wildfire, right? This was in 2012, 13 timeframe. They had just moved all of their dispatch operations into one big room. The room was double this size. And there was a row of call handling solutions down each side. And then there was another row where non-emergent calls were answered. And so this was kind of like their triage line. And then you had fire, EMS, and law enforcement. Okay, so if it was a specific call to each of those. And they were all pretty busy. I'm not going to lie. They were all really busy because they have Round Rock, Austin Travis County, you know, all these different dispatch centers. They had a big accident up on one of the freeways and they pull it up so everybody's looking at it, right? And I kind of felt like I was in a room with maybe the sales of stocks, you know? It was like everybody stood up and they were all chatting and talking and can you get this, can you get that? And I noticed on the wall there was a clock. And I asked somebody, I said, what's the clock for? Because it had 10 minutes on it. She said, oh, that's how long the calls have been on hold. And I said, really? 10 minutes. And I said, does that go down? She goes, no, it has to be answered in triage, has to be answered by, you know, somebody and then transferred, but these guys are all busy with this incident. I share that story with you because in Wyoming, we're still filling the seats with the same pool of people. But for me personally, I don't want to sit on a phone call for 10 minutes. And so I understand the cost of 911 is expensive. I understand that we got to look for efficiencies, and I do think that there's some solutions. I just don't want to be a part of a system where we wait 10 minutes for a call to happen.
So nobody does, and I'm not suggesting that, but I honestly believe we have a lot of dispatch centers. When you have 30, you have a lot where there's nothing happening either. And if we have a robust system where centers can back each other up, So if there's overflow in one, it goes to another. And we never, ever see anything like 10 minutes. We never see anything more than 30 seconds, I hope.
You're right. The redundancy of the system that Next Gen 911 provides is huge. Like when we had the outage, so last year, Saratoga closed one of their PSAP. And all the calls ended up going to Carbon County, except for there are some that goes to the city of Rollins, right? Last week, they had a large power outage. It caused for failure of all calls to be transferred from one phone provider within our state to a PSAP. A lot of it happens with technology, you know. And they were down for, I know, for over 24 hours. And you're right, that new technology be so handy because it would create a tertiary, up to a tertiary call flow. So if your PSAP goes down, there's an automatic switch that flips and it goes to another person. Or if you're overcome by calls, let's say, you know, Teton County has a major incident and too many calls are coming in for them to answer. Possibly calls could be answered in Lincoln County. You know, that technology option is so important, and I hope we get there soon.
It could be in Teton County that a Republican got elected and it caused everybody to go crazy. Keep going. These poor people want to go home and we need to finish up.
That is all I have off of those two projects. I'm happy to answer any questions.
Thank you, Mr. Chairman. Thank you, Ms. Benning, for being here. I have a question on, you're in contact with all of the 911 agencies throughout the state and the PSAPs. I have requested in the past, but I haven't seen anything. I'm requesting this of you today is an inventory of the 30 centers and what they have, what's usable, what's not usable, everything from electronics to vehicles to I'm not really sure what all they have. Computers, just not sure. I would like that because I think the taxpayers deserve to see a list and to see what we have paid for and what we need to go, what we will need going forward. In the past, there has been some communication. I'm from Park County, and our person up there has tried to get some estimates, and they were all over the map as far as what one county would need, which is why I voted in favor of this, is to say, hey, this is something worth checking out. Each county may or may not, most will not be able to support and fund their own next-gen emergency services. I would like to see what we have, what we can use, and what's outdated.
Ms. Benning, can you help with that?
Chairman and Representative, I believe that that information will be represented in the final format of your study. I don't know that we will have that inventory during that first report out, that interim report out. But I have asked for them to get a complete inventory because it's very important moving forward. If you have certain call handling companies that are being used in a PSAP, when you create a next gen 911 network, they have to match up, and they have to match up even as far as the version that they are using. And so it's really, really important for us to have that inventory. I do not feel that I will have an inventory though on the vehicles. I mean, I've literally just asked for inventory on the operational side of 911. Would that be sufficient for you?
Representative Weber?
Mr. Chairman, thank you. I would prefer to have a complete inventory.
Okay. I'll make a note.
Okay. Any other questions for Ms. Benning? Really appreciate you coming and hanging out. And I know this is the funnest committee in the world, so thank you. Mr. Agopian.
Mr. Chairman, Nicholas Agopian here for the Wyoming County Commissioners Association. It's been a fun meeting. I've caught the whole meeting. I was here at the first topic, and I think the agenda could have reflected stakeholder instead of stakeholders this afternoon. The main reason that I'm here today as a stakeholder is to tell the committee that, and I think Representative Nina, directly to your question, the success of the study that this committee directed WIDOT to undertake through their CIO office is going to take some time to do that inventory. And that's what we're moving forward. And then that inventory is hopefully where we're going to find the efficiencies when the state moves forward with the next gen 911 system. And it's my understanding, to the chairman's concern, that the numbers don't add up with the number of counties. 30 PSAPs, 23 counties. That part makes very clear sense to me. And I believe the goal is to find those efficiencies by using the equipment in a more regionalized way. And then hopefully, as this committee moves forward and takes that information from the study, I'm hopeful that the study, that what you see at your second meeting, has a significant amount of detail that drives this committee to want to move forward into the next session. And we don't wait until 2028, because the sooner we do this, the more savings we will find. And we will be able to redeploy the existing fee that is currently on phone bills. And I think, to Representative Webb's question and likely concern, the appetite, I don't see there being a statewide appetite to increase that fee. And so, especially as I look at a committee that sits on top of a significant wealth in this state. And so as we look forward to working with the department, the counties, and if there's ever an issue, Amy, I hope will pick up the phone and call me. We're going to make sure that we get through and are as responsive as quickly as we can be to the survey and accommodating these folks so we can move it forward faster and find those savings. Because what happens now, where we have one or two communities that have this next gen 911 service that they've paid for, I think Park County is one of them, but they still have to and are required by federal law to maintain the old system. So it's inefficient in and of itself. And so in that regard, we want to move as quickly as we possibly can. And I think even if we start talking towards the end of this interim about what are those standards in the PSAPs. Over the years, since the 911 fee was put in place, counties have used these call centers in a variety of different ways. And if the state is going to step in and assist in providing these services as an essential government function, it seems likely that there should also be a standard for what that equipment is and how we move it forward. That would make a lot of sense to me. But it's Friday. I could go through all of our needs for the 23 counties if the committee would like, but I don't really want to. I'd really like to get on the road. I really appreciate the care that this committee has taken the last 2 days. And again, thank you so much for stepping up at the last committee or during the last session to bring forward Senate File 32. I think it passed unanimously out of the legislature.
Thank you, Mr. Agopian. Any questions for Mr. Agopian? Thank you both very much. Safe travels. Is there any other public comment in this room? Noah, is there any other public comment online? Mr. Thompson? Here he comes. You look tired, Mr. Thompson. You probably want to go relax tonight.
Mr. Chairman, thank you very much. I'm definitely not as tired as you guys might be. I just want to let you know that I have been, listening in to the conversation, and if there's any questions or anything that you guys might have for WASCOP, not all PSAPs fall within our purview, but most of them are operated by members of our organization. We've been working with Ms. Benning and the crew at WYDOT, and are looking forward to moving in the right direction in the short term and the long term over the next 2 years. And I'd be happy to answer any questions if you have any, sir.
Thank you for being the last man standing, Mr. Thompson. Any questions from the committee? I think we all want to get to the same place on this, Mr. Thompson, and we appreciate you and all your members. And Department of Transportation, Zelensky, we're kind of mad at, actually, so we if he's listening in. Mr. Agopian, we appreciate you. Anything else to come before the committee? Anything else to come before the committee? Be sure and get your travel thing in. I think you already have. They're all there, and safe travels, okay? Safe travels. We're adjourned.